collect our sign sheets.
Where's that?
Beg your pardon?
Right back here. On the table behind me. It's still a little bit hard to hear you.
The sign sheets are on the back table.
Sorry, I think I can adjust my volume. So please sign in if you would like to provide testimony regarding the facts of this case. I would remind everyone that we are not the Planning Commission, we're the Board of Adjustments, and so we're not taking public comment pro or con the development. It's specifically about the facts of the case. So a number of people were not here last time, couldn't be unless you duplicated yourself. So I'm going to read through our procedures. Is there anyone who has not signed up that is trying? Okay, go ahead. So would like to thank all of you for being here this evening to participate in this process. One of the primary functions of this board is to receive well, actually, that is not correct. This is not correct. Beg your pardon. What did we prepare to discuss? Oh, wait, that was me. So here's our procedures for tonight. We made, for those of you who were here last time, we started late, and I apologize for that. It was a waste of your time and ours. So we apologize. I'm glad to see so many other folks here tonight. We did begin at 7 o'clock as promised. We'll ask all individuals except the attorneys intending to provide testimony to, as a group, swearing. So please prepare yourself for that in just a moment. We will first hear from the city planning director, then the appellant, and then the applicant and developer. Each will have 15 minutes to present their case. All three will be allowed to call witnesses. We will open the hearing for testimony from the public at that point. Ask each speaker to limit their testimony to the appeal we are considering and not provide opinion about the project in general, pro or con, or other matters related to the city. We care about all of those things, but that's not the point of being here, and there are very many people here who wish to speak, and we want to make sure we respect everyone's time. Thank you. We will not limit the overall time allowed. We discussed that. We decided we want to hear from everyone who wants to provide testimony, or the number of people who wish to provide testimony. The city charter does not specify whether a Board of Adjustments hearing should allow public testimony, and although all parties and the Board of Adjustments agreed prior to the last meeting through their attorneys that there would be no public comment, this was not the expectation of the public, obviously. There were many people in attendance, but the meeting had not been properly noticed, and so that's why we continued it to this evening, in case you weren't aware of that. So the meeting was properly noticed, and I assume that's why there's more people here this evening. And welcome. After closing the public testimony portion of the hearing, we will open to board member questions for whatever time is necessary to answer the questions and for clarification. Each of the three parties after that will have 10 minutes for rebuttal and summation in this order, not the same order. The city planning director, then the applicant developer, and then the appellant. Any members of the board of directors can make a motion to go into executive session to discuss procedural matters. It will also be acceptable in executive session to discuss whether including particular facts or interpretations in a resolution would be legally appropriate or defensible. However, in general, board members should plan to conduct decision-making deliberations in the public hearing, so you all can hear our thoughts, including aspects of a resolution that the board asks its attorney, Mr. Tuthill, to include in a draft and bring to a subsequent and again continued hearing. It is also possible that a motion is made at this meeting to adopt a proposed resolution on which the board can vote, or the meeting can be continued so a resolution can be drafted and voted on at a subsequent meeting. A resolution means doesn't imply it would be pro or con, it's just whatever it happens to be. We reserved January 22nd for this eventuality. Okay, those are the procedures, and we'll ask the secretary to take roll.
Member Miller,
Here.
Member Sinks. Here. Member Hill.
Here.
Member Cum.
Here.
Member Bartlett.
Here.
Member Stone.
Here.
We have quorum.
Thank you. So there are, on this list, I have just one sheet, is that correct? Okay.
Yeah, there was only one sheet for the sign-in. If anyone else wants to sign in, please sign in on the sheet on the back table and place it right here on my desk.
So on the sheet, there are 3 names of folks who have wished to provide testimony. So we'll ask you to stand, and also Mr. Parker, and any other witnesses that the attorney's planning to, the secretary will swear in.
Do you swear that the testimony you are about to give will be the truth?
Thank you. Okay, we have already read the case in. I don't believe we have to read it in again. Let's do just a thorough.
Case AP-19-001, novel White Fence Farm appeal, continued from December 4th, 2019.
Thank you. Okay, so,
Mr. Chairman, I propose that we put everyone who wishes to speak tonight also on oath, or are we going to do that later?
everyone who in the public,
Yes,
all of those folks have already sworn in.
okay, thank you.
If later on, if anyone else feels that they would like to speak, we'll consider that and we'll have to swear in at that time. Okay, so let's begin with the city and planning director.
Thank you, Mr. Chairman, members of the board. My name is Lauren Stanek, and I'm an assistant city attorney with the city. I'm going to be preparing the argument tonight, and Mr. Parker is going to be preparing our rebuttal. We're here tonight on an appeal brought by the Wildflower Patio Homes Homeowners Association, collectively referred to as the homeowners, represented by Mr. Silvestro, regarding Mr. Parker's interpretation of the Lakewood zoning code. As I am up first tonight, I have the pleasure of explaining some of the background information as to how we got here today, as well as explain how Mr. Parker's interpretation tonight is supported by evidence in the record. As you all know, a typical city like Lakewood is divided into zone districts based on their uses. This is where we get zone districts such as residential, commercial, mixed use, etc. Most established cities have been this way for about 100 years or more. In the last 30 to 40 years, the planned unit development, or PUD, became an alternative method for zoning property. In the present case tonight, to avoid using too many acronyms, I'm going to refer to the particular plan we're discussing as the Official Development Plan, or ODP, and not a PUD. Cities started to realize that they embraced this concept, how inflexible ODPs made their city in any kind of development or redevelopment. You could almost picture it like a patchwork. As cities progressed and development and redevelopment became smarter and more varied, cities like Lakewood were stuck with this patchwork of zone districts and ODPs. There were more and more one-off zone districts that couldn't, or wouldn't allow for certain development or redevelopment. This is where the zoning code updates came into play. The zoning code was rewritten in 2012 and adopted in 2013. This rewrite was substantial. Of note, the rewrite removed almost all of the existing ODPs, remapped the entire city, created new zone districts, and helped clarify standards to make information more readily available and easy to understand. This rewrite was precipitated by many things, but it was clear that cities, like Lakewood, needed to be able to change with the times. The City Council and others realized that you can only keep adding more and more unique development plans before they overwhelmed the system and made it almost impossible to understand what could or could not be developed or redeveloped and how. An ODP like the one in this case is designed to apply to the development approved under the ODP. Redevelopment, like the kind we're talking about here, can follow either the ODP or the regulations for the base zone district. The intention of an ODP, like the one in this case at the Willow property, is not to create perpetual characteristics for a piece of land, but to control the initial development. As I alluded to already, these ODPs became outmoded as time changed because they cannot account for possible redevelopment or foresee what the city's needs are going to be down the road. They are subject to the same rules as those in straight zone districts under our code. The city had to come up with a way to reconcile the ODPs that were being kept after the rewrite with the zone districts. This is how we ended up with a situation where there was an overlay and base zone concept. The ODP, like the Wilson properties, was the overlay zone district, and whatever the zone district was in that particular area operated as the base zone district. Mr. Parker and his staff addressed this particular issue when they worked on the rewrite. Before City Council in 2012, Mr. Parker specifically noted that ODPs like this one were, and I quote, "were all written for individual cases and individual pieces of property and to meet a set of needs at that time. And one of the problems is that they don't change with time. They don't age with the property," end quote. He went on to discuss a specific example of what happens when there's an over-specification of uses. The city can be zoned into a corner if they zone something specifically and only for, say, an assisted living facility. Now that property cannot become anything else, even if people in the public wanted it to become a fire station or a park. As Mr. Parker stated in his letter to Mr. Silvestro, dated May 21st, 2019, when the ODP in this case was approved in 1982, the Wilson property ODP was the full extent of regulations for this property. From 1982 to 2012, that controlled all initial development. In 2012, after Lakewood City Council adopted the new zoning code, the ODP was then subject to the new code and requirements of the base zone district. This particular area, as the subject of this appeal, was zoned mixed-use neighborhood suburban, or MNS. This brief history brings us to how can these coexist? What did the foundation mean for the planning director, Mr. Parker, when he received this application from Crescent Communities? I'm going to move on to a brief history of the application process. A pre-planning application was received for the property in 2018, shortly before the White Fence Farm restaurant closed for business. The formal application was then received in early 2019. The planning department and other city staff received inquiries from neighbors and community members about the application. In response, the new application was discussed at a number of meetings, including a Ward 3 community meeting and at least 3 other meetings held with representatives of the community. While some concerns were resolved during these meetings, there were 3 primary concerns that remained. These were the allowed residential density, the building height, and the design review authority. A formal appeal of the director's determination on these issues was submitted in July of last year, and tonight's meeting is to decide those appeal issues. The 3 issues hinge on whether Mr. Parker's interpretation of zoning code is correct as it relates to the proposed redevelopment of White Fence Farm property. If the board finds that there is some competent evidence in the record to support Mr. Parker's interpretation, we ask that you defer to its interpretation and allow the proposal submitted by Crescent Communities to proceed. Some of the relevant provisions of the zoning code that I'll be referencing are Article 1, which authorizes Mr. Parker to interpret and apply the provisions of the zoning code, and Article 3, which addresses the permitted uses and states that the permitted uses in any planned district are determined by the underlying zone, not any existing ODP. Who is best to interpret what they've drafted but the drafter themselves? Some may argue today that this is self-serving or improper. However, any jurisdiction that has a zoning code has someone tasked with its interpretation. In 2012, City Council understood and was told the interpretation would be done by the planning director, whether that was Mr. Parker or his successor. The council sanctioned this and gave it their stamp of approval when they adopted the code as is, with the understanding that it was Mr. Parker or his successor's duty to interpret the code and make determinations about what is or is not permitted in each zone district. They didn't ask to have a panel or an independent body interpret the code. They specifically granted the planning director this privilege. The first issue tonight is one of use, specifically the number of dwelling units permitted in this zone district. This is controlled by the underlay base zone district, which in this case is MNS, as I already mentioned. The zoning code controls because under Article 3 additional uses, It states that all PD districts shall allow the uses identified for at least one zone district. A PD district may include uses not allowed in the base zone district. However, the use or uses added to the base zone district shall be, and it continues, the ODP is allowed to add to the permitted uses but cannot limit them under the zoning code. The application seeks to add an additional 234 dwelling units. The homeowners argue that based on the ODP in the existing dwelling units on the Wilson property, the most units that would be permitted would be 151. Under the zoning code, and specifically Article 3, Mr. Parker can defer to the ODP if it were permitting more or adding to the number of units in the base zone district. But he cannot defer to the ODP where it is missing or taking away what would normally be permitted for this base zone district. In the above instance, deferring to the ODP would result in limiting what would normally be allowed based on that underlay zone district MNS. Because this issue involves a use rule, the zoning code and Mr. Parker's interpretation of that controls. The second issue from the homeowner's perspective is the dispute about the height of the proposed development. This is a form rule. The homeowners association objects to the 54-foot height, stating that the ODP only allows the maximum height to be 42 feet. In her letter dated July 24th of 2018, Ms. Mueller, a project planner for the city, notified the developers that the maximum building height is 42 feet per the ODP and zoning code. However, she correctly stated that the zoning code allowed an increase in the maximum height of an additional 12 feet, bringing the total to 54 feet if the developer took advantage of the LEED Gold certification. The certification incentivizes developers to build affordable housing and sustainable buildings. Any developer who complies with and obtains the certification may then exceed the 42-foot limitation and can add an extra story for a total of 54 feet. This certification applies to any zone district, including those with ODPs, like this property tonight. Even though the ODP set a height limitation at 42 feet, this height is more restrictive than what is permitted for this base zone district. It is not allowing any additional permissions under Article 3, but rather taking permissions away. In this case, the certification and thereby height extension of 12 feet is permitted in all zone districts in the city, including the base zone district where this property sits. Since developers are permitted to obtain the certification under the code for all zone districts, they would be permitted to build 54 feet and follow the requirements of the underlying base zone district. The third issue is one where the ODP creates additional requirements beyond that of the base zone. The Homeowners Association correctly says that the ODP requires, and I quote, all architectural plans to be approved by an architectural review committee of the Property Owners Association, end quote. Mr. Parker and his staff comply with this requirement if ODPs have similar language where architectural committees have actually been formed. Two examples of this are the Belmar and Denver West Architectural Review Committees. All proposed projects in these areas go through those committees for input and approval. If, however, a proposal is submitted and there is no committee in existence, the planning department processes the proposal without this step, even if the ODPs contain this language. When the proposal in this instance was submitted, Mr. Parker and his staff processed the proposal without consulting an architectural review committee for the Wilson property ODP because there was no evidence that this ODP had an architectural review committee in place. Moreover, every previous development subject to this ODP had been processed without review by an architectural review committee. Whether one was created after the fact makes no difference to the city because the city planning department would process the application as the rules were when it was submitted. The city would not retroactively submit a proposal to a committee that was formed later for approval or input. This would present an undue burden on the city and developers if they were required to wait for some unknown amount of time while a homeowners association assembled a committee or assembled one after a submission was already reviewed and underway. If this were permitted, it would essentially halt any development or redevelopment in an area where an ODP exists and put both the city and developer at the mercy of the committee for however long it took to assemble and evaluate the proposal. Along with these three main issues, there is indeed a fourth issue up for discussion tonight that is relevant to all of the three of these issues. That is of redevelopment within a planned development district. As specifically discussed with City Council in 2012, ODPs that were kept in order to regulate existing developments were not meant to limit or prevent future redevelopment. For this reason, language was specifically added to the ordinance stating that redevelopment within a PD district may apply either the standards of the base zone district or the standards of the ODP. This language was intended for exactly this scenario, when an original development built under the ODP is demolished and someone's seeking to replace it. While the applicant has submitted their development for review under the ODP, they have the right under the ordinance to set aside the ODP altogether and develop under the MNS Base Zone District. Your decision on the previous three issues is independent to this right. Each of the three areas above have competent evidence in the record to support Mr. Parker's decision, and his interpretation should be given deference. While the primary goal is to view Mr. Parker's interpretation in light of the evidence in the record, it is also important to assess his credibility and why he should be given even more deference in this current situation. As stated before, Mr. Parker and his staff worked tirelessly for several years to rewrite the zoning code. He knows what was removed, amended, rephrased, and everything in between. He also knows why. But this is not just because he was the drafter that his decision should be given deference. He has been involved in planning for over 20 years and has assisted at least 5 cities, including Lakewood, with drafting and rewriting zoning codes and respective ordinances during that time. Notably, he worked in Washington, D.C. for just under 10 years, and during that time coordinated a comprehensive plan rewrite and update of the D.C. zoning regulations. The topic we are here on today is a topic in which he is an expert. He has decades of training, experience, and general knowledge on how to draft and interpret zoning codes. His prior experience is not the only reason his interpretation should be given deference. Deference is given to those interpreting these types of ordinances and regulations in courtrooms all over the country. Although we are not in a judicial setting, when these types of cases and issues go before a judge, the law is clear that the people charged with interpreting zoning regulations are entitled to deference. It makes perfect sense that this is the case. These individuals who draft and interpret the ordinances and regulations are familiar with the history, terminology, and concepts. They've seen them firsthand in application, and judges will not disturb their interpretation unless it is clearly erroneous, arbitrary, capricious, or unless there is no competent evidence in the record to support their interpretation. In this instance, the interpretations are consistent with previous practice and the clear language of the zoning ordinance. There's no evidence of erroneous, arbitrary, or capricious action on the part of staff, and there is certainly significant evidence in the record to support Mr. Parker's interpretation. In closing, the position and arguments I have made today, while true, are not those of an expert. Mr. Parker, the city's planning director, is truly the expert in this field and of these specific issues. He will be available to the board to answer any questions at the end of the arguments tonight. And at the conclusion of the hearing, I'd ask that you find there is more than enough competent evidence in the record to support Mr. Parker's decision and his interpretation of this matter. I'd like to thank you all for your time.
Thank you. Yes, sir. Yes, please.
Good evening. My name is James Silvestro. I'm a land use attorney with the law firm of Ireland Stapleton. I want to begin by thanking city staff and, of course, the board for your careful time and attention with these very important matters. As you can see by the turnout here, these are very important decisions for the community, and we thank you for your thoughtful consideration. I'm here tonight on behalf of 2 appellants. The first is the Wildflower Patio Homes HOA, which is the HOA in the northwest quadrant of the property that's covered by the Wilson Property ODP. The Wildflower Patio Homes has actually come together with other HOAs and community members, neighbors, subject to the Wilson Property ODP, many of whom are here tonight, to form a Colorado nonprofit called Unified under the Wilson Property ODP, whose sole purpose is to ensure that the land use standards set forth in the ODP are enforced and respected by the city. Before jumping into the legal issues, I want to highlight 5 unique elements of this ODP, which, as the city has acknowledged, remains in force. The first is that it was adopted in 1982, and it was recorded against title to all of the properties subject to the Wilson Property ODP. And what that means is that anyone who has bought incense there or even thought about buying in to that property was on notice that any uses at the Wilson Property ODP were subject to the land use standards set forth in the ODP. Second, the ODP itself was retained as part of the comprehensive rezoning that Ms. Stanek mentioned in 2012. That means at the same time that the city council was adopting the new zoning ordinance, it also looked at this ODP and expressly retained it and said, this ODP has continuing efficacy. There's context-sensitive issues at this specific location where these standards should remain in force. The ODP itself has never been modified in a way that would weaken any of these land use standards. All of those standards are more restrictive than the standards we heard discussed just a moment ago under the MNS-based zone. And then finally, a very unique element of this ODP, at the time it was put in force, it was an agreement that was signed by the city, but also all of the subject landowners. And amongst those landowners within the Wilson property, they added in a provision that said that the ODP would run with the land and would be privately enforceable by anyone who owns property within the ODP. So the decision that we're looking at tonight, as Ms. Stanek mentioned, was sort of a two-part decision. The first iteration came May 21st, 2019. Ms. Stanek discussed this theory of use, and the idea is that following the 2012 rezoning, Director Parker says that, well, the base zone uses must be allowed, and therefore any standards you're trying to put on top of it that would stop those uses is not okay. The issue with this thinking is that it conflates uses with standards, and it does so in a manner that's not supported. Uses tell you what you can do with the property. Standards tell you how you can do it. We're not disputing the fact that this property following the 2012 rezoning can be used for multifamily. That's not the basis of our objection. The issue is when it comes to something like residential density, where the ODP very specifically says what the maximum amount of people that we can cram into this property is. The change in 2012 can't roll that back. That's been in place since 1982, and it's privately enforceable. And then coming back to this alternate argument, it was actually 10 days later that Director Case followed up with another letter, Director Parker followed up with another letter saying, oh, and also if we don't want to go under the ODP at all, there's this other provision, again, adopted in 2012 when the city expressly retained the ODP itself, that would allow me to pick and choose whichever standards I feel like applying. The bottom line with either of these decisions is that Director Parker has found that the land use standards in place under the ODP since 1982 and never changed can now be ignored for this new development. There's really two issues on appeal tonight, and Ms. Stanek went through them, but I think it's important to underscore the fact that any decision from this board must address all of these issues. The first is whether or not the proposal from Crescent violates the standards under the ODP. And I submit to you that it's a black and white matter, objectively true, that the maximum residential standard would be violated by this proposal, the height standard will be violated by this proposal, and the architectural review standard under the ODP will be violated by this proposal. Then ultimately, you all need to decide, can those standards be ignored? With regard to the maximum density standard, I've got the language right here. The ODP is in 3 in your package if you want to refer to it yourself. But I've blown up the maximum residential density standard here. And it shows that the maximum allowed within the Wilson property is 380 dwelling units. As it exists today, there are currently 229 dwelling units, leaving a balance under the ODP where someone could come along and build 151 additional dwelling units. What Crescent's proposing is 234, 83 additional units over what is allowed under the ODP. Second, the height requirement under the ODP is black and white. It says buildings at the White Fence Farm property cannot exceed 42 feet. There's no provision for a waiver or a variance or any sort of environmental incentive, nothing about LEED sustainability in the ODP from 1982. What the city has tried to do is mix apples with oranges and say, well, the ODP allows for 42 feet, but then we're going to borrow this other concept from the base zone, which has no applicability to the ODP whatsoever, to allow you to go up another 12. Again, it's black and white. The limit under the ODP is 42 feet. Crescent's proposal is to build 2 different buildings that will be 54 feet tall. And then the final standard under the ODP is that all plans must be reviewed by an architectural committee of the neighbors. The city has taken the position that this has somehow been waived, but they don't actually cite any authority for that concept. There's nothing to say within the ODP that if you use it, you lose it. Some of these folks, the ODP has been in place since 1982, but there hasn't been very much development in the last 20 years. Some of the folks might be new. I don't think it's fair to say that, well, because there wasn't a standing committee since 1982, that somehow you have no control over what's built in your community. So given those obvious violations of the ODP, then the question really becomes, can the Wilson property ODP's land use standards be lawfully ignored? And there are three interpretive tools that I want to just go over quickly to help you resolve what's an obvious tension between the ODP and the base zone that was added in 2012. The first is that the zoning ordinance doesn't say anything about deference to Director Parker. Ultimately, this board decides what land use law is in Lakewood. And so, yes, there is case law to say that when a city makes a decision, a judge looking at it after the fact should give that decision deference. But this is the body that makes the decision. If there's a subsequent appeal to district court by either party, your decision will be granted deference, but ultimately it is up to the six of you to decide whether or not these ODPs that were retained after 2012 can just be thrown out whenever the next developer comes along. The next standard that'll help guide your decision is it's an express provision, again, added in 2012 at the same time all these other things were happening, that says if you end up in a position where you can't tell heads or tails, you can't figure out how to reconcile the ODP that was retained in 2012 with maybe the other standards provision that was added in 2012. The code tells you how to break that tie. The more restrictive standard must control, and here the more restrictive standard is the ODP. And then finally, I mentioned at the outset that this ODP is unique because it includes an private agreement that runs with the land between the private property owners. Again, the code tells you what to do. You cannot interpret land use law in a way that will interfere with this private agreement, which has never been modified by the affected homeowners. So flowing directly from these rules, I think there's really two independent bases that this board must find that the ODP cannot be ignored. The first is that when all these other provisions were added in 2012 and the city threw out a bunch of outdated ODPs, it expressly retained this ODP. It said, yeah, these are unique standards that apply to this unique property, and we, the city council, are going to keep them in place. The second independent reason is because of that private property right. The people who have bought into this community, who saw the ODP recorded against their title, relied on the fact that this could not be changed on a whim and that the ODP would remain in force. So with respect to what happened in 2012, I think it's important to take a step back and think about what the purpose of creating the PD zone was. And it's what I just mentioned. The city wanted to retain certain ODPs, and that's exactly what the city did here. It threw out the ones that were outdated and that didn't apply, but for the ones that were still in effect, that still governed the local context for the neighborhood, that included land use standards that were unique to that community, the city council retained it at the same time it adopted all these other provisions and added in a base zone which allowed for additional uses. Again, we don't dispute. Ms. Stanek made a point that, who better to tell you what the code means than the person who drafted it? I think the point there is who better to tell you what a code means than the person who drafted it at the time that they drafted it. We found the 2012 legislative history where Director Parker testified in front of the city council and explained for the ODPs that we are keeping, they will stay in place and we will not change one single word of those PDs. Senior Planner Kara Mueller confirmed that this remained the city's position as of June 2018 when she wrote to Crescent during the pre-application process that the base zone applies to the property, but the standards set forth in the base zone only apply, they only govern where the ODP is silent. On the three issues that we brought here before you tonight, the ODP is clear as day. It's not silent. It tells you exactly what standards apply to this use. Turning to the issue of private enforceability, again, this has been in place since 1982. At the time, it was approved by the city and all of the private property owners as an agreement amongst themselves. It was recorded against title such that anyone that's bought in has had record notice of the existence of these controls. And then most importantly, the owners who agreed to this ODP specifically stated that it would run with the land and that any property owner within the ODP can enforce the restrictions set forth in the ODP. And again, recently the city has confirmed that the only way you can manage these ODPs that include private covenants is to get the consent of the affected neighboring landowners. Item 19 in your packet has a quote from City Attorney Mr. Cox. At a City Council hearing on July 22nd, 2019, there's a rezoning of an ODP, and you explained that you can only do that in circumstances where the affected landowners under the ODP have all given their consent, because the ODP itself exists as an agreement separate and apart from the base zone. Here, Crescent has never sought the neighbors' consent, and obviously the neighbors have not had a chance to give that consent. Similarly, going back to 2012, again, this is Mr. Cox in the hearing where the comprehensive rezoning was accepted. He's explaining in this quote that I pulled out, item 23 in your packet, that private covenants can exist that go over and above the base zones. And that's exactly what we have here. We have an ODP that was agreed to between private properties that runs with the land that can go over and above the land use standards set forth in the base zone. There's nothing wrong with that. So finally, turning to Director Parker's alternative theory, there are a few different issues with this. I mean, at its most basic, I think the task before you is reconciling the fact that there is a conflict between the land use standards in the ODP and the land use standards under the base zone. I would submit to you that if the ODP, as Ms. Stanek mentioned, is an overlay district, then what's happening with that ODP is that standards are being overlaid on top of the base zone uses. And that's all we're asking you to do. This provision relates to redevelopment, but it doesn't define what redevelopment is. And I would submit to you the only way that this provision can make sense, again, adopted in 2012, with what the City Council did in retaining this ODP in 2012, the only way that makes sense is if redevelopment means something more than what you have here. Here you have Crescent proposing to develop less than 10% of the entire Wilson property ODP. And I think a fair reading of section 17365A that doesn't nullify an ODP that was retained in 2012 would be to say that this other standards idea where you can pick and choose only applies when property owners within an ODP, all of the property owners agree on what a redevelopment should be. And again, this interpretation of this section by Director Parker is inconsistent with Director Parker's own words in 2012. If the adoption of this provision allowed the city to just throw out ODPs, then it makes no sense at the same time they were adopting it for him to say, we will not be changing one single word of these PDs. And then the last issue with this provision is that even if it did apply, it allows you to pick and choose standards, but it only allows you to pick between the base zone standards and the ODP standards when base zone standards actually exist. And on 2 of the 3 issues here, maximum residential density and the neighborhood architectural review, the base zone actually doesn't provide for any standard whatsoever. Under MNS, there is no maximum residential density. We put 10,000 people on this property. So to say that you can pick and choose between either standard when there is no standard, that it doesn't make sense. And similarly, there is no neighborhood architectural review under the base zone. Ultimately, I think that the 2 key points here are that the ODP was retained in 2012 by the City Council at the exact same time that it added these provisions, that it added the base zone. If you can't reconcile the conflicting provisions of the ODP with what happened at the exact same time, then the code tells you what to do. You have to go with the more restrictive standards under the ODP. And then the city really doesn't have an answer for the private enforceability piece of this. The private landowners that will be affected by this, that have the authorization under the ODP to enforce the ODP, have never agreed to amend it. And again, section 17162C tells you all what has to happen. You cannot reach an interpretation that would violate that private agreement. Thank you very much.
This is good. City lawyer, no, she was a lawyer. She just read us. Jesse.
Good evening, board members. My name is Mike Smith from Brownstein High Harbor Shack, and I'm Land Use Council for Crescent Communities. Tonight, we're joined by Ben Krasnow of Blaine Nisha Crescent, as well as Carolyn White from Brownstein. And we're here tonight to defend the planning department against claims that it has misinterpreted the zoning ordinance. After careful consideration, Mr. Parker chose to apply the base zone district standards established in the 2012 legislative rezoning instead of ambiguous language in a 37-year-old plan development. As the zoning ordinance is written, Mr. Parker was empowered to do so. The zoning ordinance expressly authorizes him to choose to apply the standards of either the base zone district or the ODP. Mr. Parker chose to apply the former. The HOA prefers the latter, but it doesn't make it wrong or unlawful. The zoning ordinance plainly authorized Mr. Parker to make that choice. But before we get to the substance of those claims, we first asked the board to decline to even consider this case in the first instance. And that's for two reasons. First, a different process governs. Planning director decisions made in the context of a major site plan review are subject to appeal before the planning commission, not the board. The HOA appealed under a general provision that authorizes the board to consider director interpretations and decisions. But that's qualified by a specific provision pertaining to major site plan review and appeal. For a major site plan, the prescribed process includes pre-planning application review, formal application review, review of the interim decision by the planning director, issuance of a decision, and after all of that, a right of appeal, but to the planning commission, not the board. Here, the planning department's May 21st and May 31st letters weren't independent decisions and interpretations divorced from an application. They clearly arose exclusively in the context of a major site plan review and application. Under Colorado law, it's well settled that specific provisions govern over the general, as here. Thus, the board should decline to consider this appeal and instead send it back to complete application review. But even assuming the board, this is the right process and the board has jurisdiction over this appeal, it isn't ripe yet. We must wait until there's a final decision on the application. While the board can consider director interpretations and decisions, there's some nuance as to what that means. In some cases, the planning director may simply interpret the ordinance. For example, where someone wants to know what they can do with their property, or whether they want to know where a specific use or a building is violating the zoning ordinance. In other cases, the director's interpretation is only formalized when he actually applies it in a decision. That's the case here, where an interpretation is part and parcel of a pending application. That decision cannot be final until there's a final decision on the application. It simply doesn't make sense, and it's bad policy, and anyone can appeal the planning director decisions or statements or any of the statements from within his office prior to final action on an application. First, it exposes staff's pre-decisional internal deliberations to scrutiny. People can selectively quote pre-decisional interim statements and construe them as being inconsistent and arbitrary. And the HOA's letters do exactly that. They attempt to mischaracterize Ms. Miller's statements as being inconsistent with Mr. Parker's, but they're not. To be clear, in the record at item number 6, Ms. Miller's statement was actually that the MNS zone district governs, which has no maximum residential density. That is entirely consistent with Mr. Parker's decisions. Second, it manufactures a way to get in front of the district court prematurely. Pre-decisional statements gets teed up to the board. The board makes a decision. The board's decision is then appealed to district court under Rule 106. Then the district court reviews staff's pre-decisional statements before the city has ever made any actual decision on the application. And this was the HOA's intention all along. They filed a letter requesting interpretations a mere 6 weeks after Crescent submitted the application. That letter specifically mentioned Rule 106. They also formed an affiliated nonprofit group to fund litigation even before the city had a chance to respond. The intent is clear: delay and frustrate review of the application. Ultimately, this is a waste of resources. Planning could change the pre-decisional statements during review. It could deny the application. It could approve it with conditions. All these could make the appeal moot. Instead, the HOA asks everyone to expend resources before the planning department even gets a chance to address and make a decision on the application. Therefore, the board should decline to consider the appeal at this time. Now, if the board does find that it has jurisdiction, the board must uphold Mr. Parker's decisions. As I stated earlier, the Planning Commission and City Council both approved citywide legislative rezoning in 2012. As part of that process, City Council had to select a new base zone district for the property. And they had to select it based on compatibility and how closely it relates to the uses under the Wilson ODP. Here, City Council adopted the mixed-use base zone district because City Council found it to be A, most compatible with the Wilson property ODP, and B, most closely related to the uses under the Wilson property ODP. That decision is now binding on the property. So why is the base zone district relevant? Because of two other provisions City Council added in that same 2012 rezoning. First, City Council added this highlighted section, which states that all PD districts shall allow the uses identified for at least one zone district. So after rezoning, the property became subject to all the entitlements and standards of the mixed-use zone district, including those related to density, to height, to architecture review. Now, second, City Council also added this other highlighted section under 17.3.6.5A. That states redevelopment within a PD district may apply either the standards of the base zone district or the standards of the ODP. The effect of this provision, Mr. Parker can freely apply the standards of the base zone district. I want to be very clear about this because the HOA glosses over the 2012 rezoning entirely. In that same action, City Council did three things. It legislatively rezoned the entire city and added a mixed-use base zone district to the property. It created a new provision requiring Wilson ODP to allow all uses within that base zone district, including multifamily residential. And it added this last critical provision, which empowers Mr. Parker to apply the standards of the base zone district instead of the ODPs. I'll be referring to this provision a lot tonight, because this single highlighted sentence dispenses with all of the HOA's claims related to density, to height, and to architecture review. First, regarding density, the base zone district authorizes the project's 234 units. The M&S zone district has a performance-based maximum density limit, as well as a minimum density standard of at least 8 units per acre. Planning followed these standards and found that the project's density is acceptable. Now, as we heard tonight, the HOA contends that the density violates the ODP because it exceeds a so-called maximum density table. This table doesn't create the density limit. It's not titled maximum density standard. It appears under the header existing zoning use and the subheader land areas. The preceding paragraph states present uses of the property are and shall remain permitted uses. It doesn't state that they shall remain permitted uses subject to the following density limits. And even with respect to the property itself, the table doesn't specify any kind of density limit for parcel H. If parcel H had a density limit, the preceding paragraph would state it, the table would include that title, and certainly parcel H itself would have a limit. Instead, the ODP actually contemplates higher density on parcels G and parcels H of the ODP. This is from the ODP itself. It states, major conceptual design elements include a general increase in density from the northeast to the southwest across the site. So the table doesn't create a density limit, and the ODP actually contemplates higher density in parcels G and parcels H. But remember, to bring us back to the ordinance, even if the ODP could be construed as creating a maximum density limit or a density standard, it doesn't matter. Mr. Parker is freely authorized to choose to apply the standards of the base zone district instead of the ODPs. Regarding height, the base zone district also authorizes the project's height of 54 feet. The HOA seems to accept that the base zone district authorizes structures up to 45 feet. What the HOA contests is the height incentive. It doesn't think the incentive is available because the ODP contemplates a 42-foot limit. But this again forgets that the base zone district can apply in lieu of the ODP standards. And those standards grant an incentive height of 12 feet or 1 story if the development obtains LEED Gold certification. And here Crescent has committed to obtaining LEED Gold certification. That advances the goals of the city's comprehensive plan and advances the goals of the sustainability plan. And under the plain language of the base zone district, it also authorizes the project's proposed height. Therefore, Mr. Parker was correct. The ordinance authorizes the project's height. And third, regarding architecture review, Mr. Parker correctly decided to follow the standards of the base zone district instead of the ODPs. The HOA claims that Mr. Parker needed to assemble an architecture review committee of unspecified neighbors to satisfy the ODP. Specifically on the issue, the ODP states that commercial business parcel H will have compatible architecture throughout the total area. It doesn't define what this means. However, again, 17.3.6.5 allows the planning department to apply the standards of the base zone district. In turn, the relevant standards require planning to perform a thorough review. Article 6 includes highly prescriptive residential building and site design standards in order to ensure, quote, quality sustainable development that interacts and functions well with the surrounding community. It must also, quote, embrace the intent of the particular zone district. That sounds an awful lot like compatibility. It also spells out that staff must at least review the architectural treatment in detail, building transparency, structure variation, facades and entryways, rooftops, garages, parking. The list goes on. It's an exhaustive review. It's therefore clear that planning will satisfy the intent and purpose of the ODP. And Mr. Parker's decision was reasonable and entitled to deference. They're qualified to evaluate and apply architecture standards, and they're actually experienced in doing so. In contrast, the HOA hasn't demonstrated, let alone even claimed in their papers or tonight, that it's qualified or experienced to review architecture. The ODP itself is also internally conflicted. As Mr. Silvestro's slide said, it states that plans will be approved by an architectural review committee comprised of the Property Owners Association. It means one HOA. But it also states that one or more HOAs may be established. And in fact, that's exactly what has happened. There's at least 3 HOAs within the Wilson Property ODP. The ODP doesn't specify how you deal with that. And the ODP provision isn't even valid in the first place. It was waived. The HOA hasn't put forward any evidence showing that it ever formed a committee or required properties to undergo such review. Instead, Mr. Parker found at least 7 examples where projects were not reviewed or approved by the HOA or committee. So only evidence in the record right now is in the past 37 years, there's been 7 projects that have been completed without any kind of HOA review, or the HOA even claiming they have the right to review it. And planning didn't do anything abnormal here. Mr. Parker found that there were at least 4 other examples in the city where there are similar provisions in other ODPs that were similarly waived. Planning treated them exactly the same way as they treated those 4 projects. Ultimately, staff is fully authorized to apply based on district standards. To briefly conclude, we first asked the board to find that it lacks jurisdiction to consider this appeal. This proceeding should adhere to the process of major site plan review. But if the board disagrees, an appeal here before the board still isn't right. The interpretations aren't yet final because there's no final decision on the application that would actually apply the ODP interpretations. And if the board finds that it has jurisdiction, it should uphold Mr. Parker's decisions. City added the Base Zone District, MNS, in 2012. The ordinance authorizes Mr. Parker to apply the standards associated with that Base Zone District instead of the ODP standards. And Mr. Parker correctly applied those Base Zone District standards related to architecture, density, and height. The HOA may dislike those standards, but it doesn't make it wrong or unlawful. Thank you for your time and consideration tonight.
Thank you. Everyone to feel comfortable, including the public who provides testimony. We're going to open the public testimony portion of the hearing. The first name that I have on the list is Deborah Emmert. Would you like to? I'm going to say again that we don't want to have any applause, and we'll let you begin in just a moment. I didn't read this time, but I did previous meeting about the proper decorum. That we don't applaud, that we don't boo.
This is freedom of speech.
It's a public hearing. This is a process that requires, I think, our serious consideration and not just a popularity contest. So please go ahead, state your name.
My name is Deborah Emmert. I reside at 6028 West Colorado Lane. It's in the Summerfield Townhomes, which is part of the Wilson property. Thank you for your decision to allow public testimony in the appeal being heard tonight. I'm here tonight representing the Lakewood residents, many of whom are here tonight, who oppose the Nobel White Fence apartment development as it's currently proposed. Many of the people here tonight, myself included, have spoken numerous times at the city council meetings expressing concern over this project. We've met multiple times with Lakewood planning employees and with Mayor Paul to discuss how this project would violate the conditions of the contractual agreement between the property owners and the residents living within the Wilson property ODP and the city of Lakewood. As you know, this ODP was approved by Lakewood Planning Commission, the mayor, and Lakewood City Council in December of 1982. The extent of opposition to this development as proposed is much broader than just the people that you see here tonight, and we have gathered hundreds of signatures in opposition to this, both within Ward 3 as well as across Lakewood. And significant financial contributions have already been received by our community, and we will continue to fight for our justice and right in this property. We know that redevelopment or development of this property is something that needs to benefit all of the citizens of Lakewood. It needs to be something that we can all be proud of. But right now, we also know that as proposed, this development will be detrimental to Lakewood in terms of not upholding a legal binding agreement between the citizens, its appropriateness, its inappropriateness of the development to the surrounding neighborhoods, which are predominantly low-density residential. The negative parking implications on the immediate surrounding households as a result of allowing a property density in excess of what was allowed under the ODP. But note that the streets in this area are much smaller than normal because of this ODP restriction, and that hasn't been considered. There also is going to be negative environmental impact on the gulch. We've had sun studies done, and this is going to cast shadows across the gulch. This is a natural resource for Lakewood that is going to be damaged. I want to also, I know I only have 30 seconds, but I like to also note that if you look at the maps included in the Lakewood comprehensive plan, this particular property is not identified for high density development. It is shown as a property, as a natural resource to the community. With regard to LEED Gold, there's an error, there's a flaw in the ordinance in that you only have to show that you are going to try to achieve LEED Gold. You do not achieve LEED Gold until many, many months after the property is completely developed, closed, commissioned, and approved by LEED. I know this, I'm a designer, I've done many LEED projects. So they can show their scorecard that they will try to achieve LEED, but they do not have to achieve it. They are granted an additional 12 feet, but don't have to actually do what they are saying they're going to do. I also know that my time has expired, but just quickly, with regard to the building permit and the fact that this hearing is not lawful because the city has not made a ruling yet as to whether or not the major site plan has been approved. If the site plan has not been approved, which no, it hasn't, but if there was a question on that, then why did the city of Lakewood allow them to submit for building permit application on June 28th? Thank you very much. I hope that you make a decision based on the fact that, you know, this is your community, but it is our community, and you're representing all of us. So thank you for your thoughtful consideration.
We would appreciate it if you would show everyone respect, including us, because we're asking you to do it. The next person who is signed up to speak has been Cobos.
Okay. My name's Ben Cobos. I reside at 1308 South Ingalls. Lived in Lakewood pretty much my whole life. I'm quite a native, but I just wanted to say I'm against the project going forward as is, and thank you for your time.
Thank you. The last name is, I believe it's Barbara Duffy. Is that right? Did I get it wrong?
How do you sign up? I'd love to talk.
There's a
You're on
sign-in
time.
sheet on the back table that you can fill out, and please give it to me.
We collected it, but we'll do it again. We indicated that earlier. Am I reading this wrong? Is it not Barbara? She's got help. Oh, thank you. So are there other people who wish to provide testimony regarding the facts of this case?
Yeah.
If you would bring that list
All
to
right.
Secretary.
My name is Gordon Webster.
I'll ask you to wait till you get.
You can pretty much hear me no matter what. Gordon Webster.
Pardon me, excuse me, sir. Why don't you give that list to the secretary,
Figure it out.
and then she'll swear you in.
Okay. So I got the.
Give her just a minute. Okay. While we're waiting for her to do that, is there anyone else who would like to provide testimony? We didn't hear our preamble, but we are not just taking pro-con comments. We really just want to limit it to the facts of the case. So, please.
Do you swear that the testimony you're about to give will be the truth?
Yes.
Thank you. Now, please introduce yourself.
My name is Gordon Webster. I've lived in this state 57 years. I've lived in the same house at 1256 South Marshall Street, which is just around the corner from, it used to be, believe it or not, Wilson's was a steakhouse originally. And I went there for my high school dance. It was what do they have in the beginning of the season? But anyways, let me just tell you this. My thought process is, I love this area. And I missed out when they decided to sell Green Gable, the country club. Apparently that was Denver. I didn't know that, because I would have been complaining about that problem too. If you look at the fact that there's so many houses already over there, condos, apartments, whatever they are, we don't have room to build what they want to build. Okay, simple as that. That's all I've got to say. You can't go to King Supers on Jewel and Wadsworth anymore and find a place to park. I'm 57. I'm having a hard time walking anymore. There's not enough handicapped spots for all of us. If you look around the room here, we're all older. We have our issues. We've lived here forever. We want our space. That should be a park, in my opinion.
Yep,
Okay,
that's
okay,
right.
hold on. This is just me. This is my opinion. I just want you to know that this community thing that they want to build, it's beautiful, but we don't have the room for it. Lakewood does not have the room for it. Plus, I could have sworn that just last year, they said that we were gonna put a cap on how much we could build in Lakewood. I think this is gonna take us over the top. I don't know that because I'm not a politician. I come here because I'm a person. And I live in Lakewood. I don't know if you guys do or not. But I'm tired of the traffic jam that we have now because of what happened with Green Gables. If we build this same thing on Lakewood side of the street, we're gonna have more drama. We're gonna have more crashes. We're gonna have more traffic problems. All I've got to say is I say no, and all these people probably agree with me. I love the fact that you guys want to make it pretty and make it a freaking park. A beautiful park.
Anyone else? Okay, we will close the public testimony portion of this hearing. I will say, though, just for clarification, for anyone who is wondering and might have felt the same, or wondered the same thing, all of the members of this board are City of Lakewood residents. We represent each ward. We are as concerned about Lakewood as anyone else here. So we will move on to board member questions. I believe Mr. Tuttle.
Chairman, I just have a question. It's unclear to me whether Mr. Parker was going to testify or not.
I believe that the attorney said that he'd be available for questions.
Available for questions and rebuttal.
Okay, so we'll open up for board member questions. We'll start with Mr. Cohen.
I do have a question for Mr. Parker. I think counsel for Crescent made a note in challenging our jurisdiction that the director of planning could easily change his mind. And that this was not I think in challenging jurisdiction, that this was not a final decision. In fact, Mr. Parker, do you frequently change your mind, or do other directors do this?
I think the more relevant point might be the plan could still be denied or changed for other reasons. I think I've interpreted the code as it was written, as it was intended at the time. So I don't foresee changing stance on the issues in front of you tonight, but I think they're saying that, the plan still could be changed or denied in general.
Okay, thank you. Mr. Smith, there's something in the discussion that has troubled me from the beginning, and I'm trying to phrase this correctly, but I wish you would explain more fully to what power or authority does a Board of Adjustment have to rule that a covenant, a restrictive covenant exists or was created in the first place? And should it rule on this, where it derives any authority or power to enforce its provisions? You make, I think Mrs. White made a very forceful argument in her correspondence that there is a restrictive covenant. I think that express term was used. And I'll find it in a minute. Although it would be in item 22, and I believe it's page 4.
Thank you. Just for clarification, I think you said Mr. Smith. Was your question for the developer or for the appellants?
This is for the appellant,
Okay.
not you.
Yeah.
And I believe the correspondence was written by Mrs. White.
So Ms. White represents the developer.
I think you meant Mr. Silvestro.
So, yeah, I think
I got it crossed up?
if you look at item 22, which is what you're referring to,
Yeah.
that's my letter.
Some kind of look at some of this stuff.
I think I got this right. Hope I'm not in error here.
Somebody else is figuring it out.
Let me come back to that question while I
Thank you.
get my thoughts straightened out.
Take your time. Commissioners, I'm sorry. Board Member Sinks.
I have a question for Crescent Communities. So if someone, would you come to the speaker there?
You want the business representative or do you want the attorney?
I'll ask the question and let you decide. So my first question is, where else have you built in other cities? Where else have you developed properties in Colorado?
So briefly, Mr. Chairman, for the record, Carolyn White, Land Use Council. This is one of the principals of Crescent, and I'll let him introduce himself and answer your question.
Thank you.
Hi, good evening. Thank you for your time. I'm Ben Krasno with Crescent Communities. I'm the managing director for the Southwest region for Crescent. In response to your question, last year, Crescent Communities was the 20th largest multifamily developer in the country. We're headquarters in Charlotte, North Carolina, with offices in Washington, DC, Orlando, Atlanta, Dallas, Nashville, and here in Denver as well. We've got extensive experience building this product type, and we really pride ourselves in delivering top of market products.
So I'm not familiar with all of those cities' rules, but I imagine that there are times for public comment within the process throughout all those cities. Is that correct?
Yeah.
Could you point to anything specifically where, through the neighborhood comment process, you listened to the neighbors and made adjustments to things based on their input? Are any specifics come to mind?
Absolutely. At the beginning of this process, we really organized the neighbors. We called for neighborhood meetings, and for a while we had a memorandum of understanding where we were willing to make certain compromises with the neighbors in order to work with them and be a good neighbor. And we went down that path and really got all the neighbors in a room together. It was only after that where they decided to appeal because they didn't want it to be 4 stories and weren't approving of the density. So we feel like we went out of our way to call the neighbors into the room and get their feedback genuinely and incorporate it. And we do have a memorandum of understanding that has been traded back and forth with the neighbors over a very long period of time. And so we adamantly feel that we have gone out of our way to appease neighborhood concerns, and ultimately, the neighbors were not approving of the height and density, and those negotiations fell apart. So we are still willing to work with the neighbors and be a good neighbor and deliver a product that is good for the community.
So, though my question, so that's great, thank you for that. So my question was too, can you point to anything specific, it doesn't have to be in Colorado, where you did listen to the neighbors and then change? Because what I'm hearing you say with this property is you heard the neighbors, but you haven't modified anything based on the input you've been given, is that correct? So I guess I have two parts. One, to tell us where you have modified, and then tell us if you're willing to continue and do any modifications.
It's hard to come up with specific examples right now, but our.
Because you don't have
in general is to be a good neighbor.
Yeah, I can't hear you.
Yes, speak into the microphone so everyone can hear.
Yeah, it's a common practice in our business is to work with the neighborhoods and be a good neighbor and do right by the surrounding communities that we work in. And so
that's
we
a
do that
no.
on every project, and we actually have a proprietary canvas session where we fly in people from all over the country and also bring neighborhood people to the table to give their input as to the vision and experience principles that would ultimately govern the development. And so it's a very common practice for Crescent communities on every single project to integrate with the community, integrate with the neighbors, and do right by the community. In addition to
that's a
that,
no?
say in this image here it's an adaptive reuse of the existing White Men's Farm building. On the image that's behind you, we are planning to renovate the existing structure and make it a clubhouse for the multifamily units. And so we are incorporating everything that we can to, again, do the right thing in this project, listen to the neighbors, and we started by calling all of the neighbors together to gather their feedback. That's how we started this process. But ultimately, the neighbors weren't satisfied again with height and density.
So one other question for now along a different line. How about previous?
Before you, were we provided with a copy of this MOU?
Mr. Chairman, the answer is no, because it was never finalized, it was never agreed to by all parties, it was never executed, it was part of the initial dialogue between the developer and the city, and it is not relevant to the legal issues before you today.
So along another line, I wonder if you have any intent to provide low-income housing within the development?
Not specifically using tax credits or a source like that, but we feel like we're providing market rate affordability by decreasing unit sizes and offering lower effective rents.
And then just my last question then. So LEED procedures, so have you in the past been denied any gold certification or not followed through with some sort of incentives that were given, but you didn't really earn them?
Never, not once. We've always followed through. We on a majority of our buildings that we develop and absolutely have every intent to achieve and probably exceed those standards for LEED on this particular project.
No more questions at this time. Thank you.
While you're there, will you tell us when LEED standards were developed? The LEED gold standard? Do you know approximately?
The date and
Not the date, just approximately.
I wouldn't be able to pin down the date as to when LEED standards were developed.
I should be able to tell you because I have the LEED AP credential, and that was one of the test questions that I do not remember.
Did you have to get 100% on that test?
Hopefully no.
No. Sorry. Let's that's fine.
Are that all the questions for?
I don't know. Yes, for right now. Oh, please, sir.
I might have some questions for Mrs. White later. And I apologize for my, not now, Mrs. White. I want to get back to Mr. Silvestro. And I apologize for any confusion. I'm afraid I'm the one that got a bit confused at this point. But if you want to retire right now, you may. Mr. Okay. Did you have some questions? Okay. Mr. Silvestro, I'll repeat my question, and I again apologize. I'm the one that got confused. In the first instance, what gives a Board of Adjustment like us the authority and power to rule, first of all, on the creation of a restrictive covenant? And secondly, if a restrictive covenant does exist, why are we empowered to enforce it, or under what authority or power would we enforce it? And I refer specifically to your correspondence, and it's actually item 22, and it is on page 7, not page 4, where you state that there's a restrictive covenant under the ODP. And if you need a moment to view it, please go ahead. I've had to take a few moments myself.
No problem, I appreciate that. What this really goes to is the interpretive tool that we're looking at. I can bring up the specific text. So again, the zoning ordinance that was overhauled in 2012 added in this provision, section 17.1.6.2C. And it specifically says that no interpretation from this board should infringe a private agreement between private parties. Now, I appreciate your question, which is how is this board supposed to determine whether or not this is a private covenant? I submit to you that if you review the ODP, item number 3 in your packet, and you just look at the language, which says that it runs with the land and can be enforced by any of the parties or their successors in interest, then sort of ipso facto, that is a private covenant. If we need to go get a declaration from the court, I suppose we could do that. But in the first instance, it is up to this board to not make any interpretations that would violate such private agreements.
Okay, thank you. I think that's all the questions I have for now. Thank you.
Thank you.
So I want to remind everyone that you will have 10 minutes for rebuttal after board member questions, and then we may have more questions after that. Board member Stone.
I just got a few questions. What is the significance of the signatures on the Wilson ODP? And what is the legal? Thank you. What is the significance of the signatures on the Wilson ODP? And what is the legal basis for voiding it? I think it's got to be the city, right?
That's that lady.
So let's be totally clear, no one's voided an ODP, right? And I should also go on to say, there's a lot of talk about covenants and contracts and agreements. The HOA can adopt, and HOAs do adopt covenants, and they enforce their own covenants. Those are not city regulations. Those are not things that I or you can enforce. This ODP was adopted by the city as a zone district. It's not a covenant, it's not a contract. It's a zone district. It's same as R16, R112, MNS. That's what it was put in place by council. It can be amended and changed by council. And that's what happened in 2012, right? The new code removed most ODPs and kept some under different rules that put them in in conjunction with an underlying zone, right? And set the rules for how they interacted with those underlying zones, where the underlying zone overruled, where the ODP overruled. So there's never, it's not a matter of avoiding the ODP, it's a matter of interpreting how the ODP works with the remainder of the zoning code in a situation where it's intended to conform with the overall zoning code and no longer be a standalone document.
I'm sorry, I'm having trouble understanding how it would not void the ODP to proceed, with the recommendation. It would void the ODP, wouldn't it? Because then you're saying those provisions aren't valid.
Well, there's two situations going on here, and I'll come back to the second one, which is that statement about redevelopment can proceed under either or, right? I'll come back to that. So far, my department has reviewed this application under the rules of the ODP as amended by the zoning ordinance. So the ODP in place with the amendments of the zoning ordinance and how those two interact. And there's those three issues: the density, the height, the architectural control committee. And we have reviewed this development under the rules of the ODP as amended by the ordinance. So the ODP is in place, the ordinance amends it in some ways as written. If the developer so chooses, or if the development is not achievable under the ODP in combination with the base zone, the development can proceed without. You're right, not voided, but not under the rules of the ODP. And that was intentional in 2012. It's in the statements that were made by council and by the planning department in 2012 when we talked about why we were able to replace most ODPs with base zone districts. Some had unique provisions that applied to the developments that had been developed under that ODP. And the ODPs needed to be kept so that the rules were in place for the developments that were in place. But the discussion at the time with the council was specifically that we had these very unique specific ODPs that apply to very specific unique developments. And the intention was never that those properties can never be redeveloped. The intention was that when those unique special developments went away, the ODP would go away, right? The redevelopment could still be done in the same way under those same rules, but in most cases, those rules were very unique to a 70s or 80s or 90s development. And when that development was bulldozed and recreated, council specifically put in language that let's revert to the base zone. And they didn't use the word void, but you're right, the ODP in those situations of redevelopment no longer applies.
I've got a couple more, if that's okay. Is that okay? So if city council decided in 2012, when we were doing the rezoning, to keep this ODP in place, I'm having trouble understanding how. I mean, are there other examples where city staff or planning department void a city council decision or overrule a city council decision that's been made in the past?
No, we're literally following the city council rules that were put in place. The city council created the rules for how to interpret ODPs that remain, and they created rules that they go away with redevelopment. The city council created those rules. We're not changing rules. We're enforcing the rules that are in place.
Okay, but they decided to keep this one in place, this ODP in place.
With the provision that they kept this one and another couple dozen, with the provision that when the development goes away and the property is redeveloped, it's redeveloped under the base zone. Thank you. Board member 6.
Okay, so I have questions for city lawyers or Director Parker. I'll ask Director Parker first. Is there only the one incentive for LED gold certification, and that is adding a story, or are there other incentives?
To my knowledge, there's just the one. So our code allows you to add a story for either LEED Gold or for affordable housing. And it allows you to do that in any zone, in R16, in MNS, in PD zone. And again, PD is just a zone.
Thank you. And then for the city lawyers, I believe, so we've heard reference to the property owner's rights within the ODP. Do you agree that if the decision is to go with the base code, because it was stated that then the property owner's rights would be violated? Is that clear enough, my question?
You're saying our neighbors' rights violated by following the language of the ordinance that allows going with the base zone?
Right. Again, the reference was that when property owners purchase their property, they purchase their property based on the knowledge of the ODP. And so speak to that.
That's true. Every property in the city has a zone district on it. Your property, everybody in this room who owns property in Lakewood or anywhere else for that matter has zoning on their property. And they bought it under those conditions, and their neighbors bought their property knowing their conditions and their neighbors' conditions. Council controls that, and council comes in and changes that from time to time. So zoning districts are not eternal, right? They're the regulations today, and council with public notice and with public hearings can change those. And they did that in 2012.
One last question for the staff, and I believe I know the answer, but just to make sure. So is it too early for a traffic study, or has a traffic study been made?
We did not bring traffic staff here, so I'm not prepared to answer the traffic question.
Okay.
But, I mean, that comes to the point that this hasn't been approved yet. Like, we're still early in the review process of this, or mid-review process of this, so these issues are not the only ones involved in this site plan, but they're the only ones, the issues tonight are the only ones in front of you tonight.
So when would you foresee a traffic study as the process, as a formal application comes, and at what point is the traffic study done?
Traffic studies are done as needed based on the demands of projects and the roads, and I am not a traffic engineer, so I don't know that I can fully answer that question.
Common sense.
Thank you.
Thank you. Board member Bartlett.
Yeah, so a question for Director Parker. And maybe to reiterate, and just for the record, has the planning department rendered any decision whatsoever for this particular application?
No, we've shared our interpretation of these issues in front of you tonight, but the plan is certainly not approved. Thank you.
Board member Stone.
So the zoning code purpose under 17.1.2, purpose and intent, item B, says that the purpose is to implement the vision, goals, and recommendations of the City of Lakewood Comprehensive Plan. The comprehensive plan, a major theme and the golden plan, is for the development to fit in with the character of the surrounding neighborhood. My question is, what decision criteria are in place or process in place for city staff when you're making decisions and recommendations to make sure that that policy is being met?
The purpose and intent are used by council when they set the rules for zoning. So when they create the standards for a zone district and when they map the zone district. And they did that in this case. They put MNS on the property in front of us tonight. They put other zone districts on other properties. So the intent of that statement is for the council to put the right zones in the right place.
I'm sorry, I'm not making myself clear.
Sure.
So the zoning code says that the purpose is to advance the goals and the vision of the comprehensive plan. The comprehensive plan, throughout the plan and in the specific goal, at least one, says that development should fit in with the surrounding neighborhood. What criteria and processes are in place to make sure that policy is being met?
And then I guess I'm not being clear myself, the criteria and policies are the regulations in this book. So our staff, planning staff, has the regulations in the zoning document, the setbacks and the height and the use table, right? And that's the regulations that we use to determine whether things are meeting the plan as set forth by the council.
Do you have a definition for character of a neighborhood? Have you defined what goes into that?
That's a council decision.
You don't care.
Board member Collin.
I finally got around to a question I do want to put to Mrs. White, if she's available. I think in your initial correspondence that's in our record, you made the mention that the opposing counsel was making a quasi-judicial issue out of whole cloth. That may not be exactly what you wrote, and I'm pushing the context on this. As you can see, I'm kind of troubled by the fact that there are alleged restrictive covenants in the original ODP, and you, of course, in your presentation, in item 21, contend a different interpretation of the original ODP than opposing counsel does. Do you have anything to add on this whole issue of restrictive covenants and whether there's one there, or what we can do about it or may not be able to do about it?
Thank you, Mr. Chairman and Board Member Cohen. Thanks for the question, and yes, so clearly, as we said in our letter, and I'll summarize here today for you and for the group, we do not believe that the ODP constitutes a restrictive covenant or an easement or a deed restriction or any other agreement between private parties. The ODP is a legislatively adopted zoning document approved by the City Council of the City of Lakewood. And just like they had the legislative authority to adopt that document and zone the property PUD back when they did in 1982, they also have the legislative authority to adopt different zoning at any time, just like they did legislatively in 2012. And the fact that there's two zone districts that are now applicable to the property is not a conflict, and there's nothing wrong with that. And in fact, the code says, as Mr. Parker mentioned and interpreted, when that happens, in the case of redevelopment, you can choose which set of standards to apply. So I'll tell you why I don't think it's a restrictive covenant. Number one, it is not an agreement between private parties. The City of Lakewood is not a private party. It is a public governmental entity, and it is approved the ODP as a zoning document pursuant to its legislative police powers back in 1982, number one. Number two, I just checked the title again, just to make sure I didn't miss it. The ODP is not recorded against parcel H. It is not in the chain of title. It is not a covenant that binds parcel H. Now, all of that is a matter for us to resolve in the district court, which is where I'm confident we will end up at some point. But that is not a matter for the Board of Adjustment to resolve. Really, the question here is, how do you apply your policies in exercising your authority as a city to regulate applications that are before you? So the whole restrictive covenant argument and whether or not it may be interfering with private rights between private parties, in my view, is a matter for those parties to resolve amongst themselves in a private forum, not in a zoning hearing or a Board of Adjustment hearing.
Am I to conclude then that you take the opposing counsel may be in the wrong forum?
That would be my argument, yes, on that issue.
Yeah, thank you.
Before you go, coming back to the question earlier about lead standards, I know you don't know exactly when they were developed, but approximately were they in existence when they were the lead standards in existence when the ODP was created? Or
In 1982?
No.
No, sir, they were not.
Thank you.
For sure.
Okay, that's all, I think that's all for you right now. Board member 6.
So, Director Parker, thank you for your work and your thoroughness. However, I do just have to ask the question, and again, it's probably already been referred to, but just directly, can you just walk us through your thinking process in going through the decision that you made to go with the base zone district?
So let me respond. We didn't. We've gone with the ODP/base zone. So yeah, there's the section in the code that allows redevelopment to proceed irregardless of the ODP. Our review thus far has not gone that route. Our review thus far has gone to review this under the ODP as modified by the base zone. And that's where we have the 3 issues of discord, the height, the density, and the ACC. Those issues are in front of you because we're reviewing it under the ODP. And those issues are interpretations of how the ODP interacts with the base zone. So I can walk through that if you like, those 3 issues. Okay. So first, the residential density. If you look at that chart that's in the ODP about residential density, you'll see each parcel in there has a maximum number of dwelling units that was envisioned in the parcel. And prior to 2012, we wouldn't have allowed any residential development on this particular parcel. There's a line, there's 0, right? There's A through G all have a number on them. H and I parcels were meant to be commercial in the original ODP. In 2012, again, ODPs were changed the way that they work, and uses were reverted to the base zone. So every ODP in the city was assigned a base zone, and that zone specifically is granted precedence for uses. The uses allowed in the base zone are allowed in the ODP period, and then ODPs can add additional uses. So parcel H under the ODP, 0 residential allowed on that parcel. Just like prior to 2012, much of the city was zoned commercial, and those districts allowed 0 residential. Our council in 2012, in their wisdom, said, we don't want commercial-only zones anymore. We want to create these mixed-use zones that allow both commercial and residential. So the entire city was remapped to allow residential in previously commercial-only zones, like parcel H. And so in doing, they assigned these base zones, they said the base zone use standards rule, and residential is allowed. Parcel H is one of those parcels. Prior to 2012, it allowed exactly 0 residential units. Now residential multifamily is allowed on that parcel because the base zone standards for use rule. I think it's a red herring to throw all the other parcels in and add them up. Each parcel in there has a number on it, and it is 0 for parcel H, but now the base zone standard rules. In terms of the height, as I said, an ODP is not a separate contract, it's not a covenant, it's a zone district. It's an R16, an MS, MNS, anything else, it's a PD. The standard, the section in the code that offers height isn't specific to a particular district. It isn't specific to MNS, it isn't specific to any residential zone. It says any zone in the city can follow this height allowance. And it was put in place by council to promote affordable housing and sustainable buildings. And if either of those is developed on site, any developer in the city, in any zone in the city, can add 1 story or 12 feet onto their project for doing one of those 2 things that council wanted to incentivize. So it's not a matter of whether we're enforcing the ODP height. We are. The ODP height is 42 plus this incentive of up to 12 feet that can be added to any zone in the city. And in R16, the height is 35. And if you look on your zoning district, and if you live in the R16 and look in your code, it says 35. But someone who does a LEED building can build 47, right? That's true across the city. Finally, the Architectural Control Committee. The existence of architectural control committees in these ODPs was one of the reasons that a lot of them were kept, because that was the sort of requirement that was created in some of these ODPs that doesn't exist in base zone districts. A lot of these ODPs have this standard. Some of them in the city have created these architectural control committees. Belmar and Denver West are two good examples. There was a time when Academy Park had one. I don't think they do now. Where they exist, as council said, we send any development to that ACC for its review. Where they don't exist, we don't, right? And that's true of a lot of, so there are a lot of ODPs that have this requirement. A few of them have created the ACCs, a lot of them haven't. And in those that haven't, there's no one we can send it to, and we can't go back retroactively and ask it to be created and apply things retroactively. So, and that's that's fairly common, that these ODPs have these standards that have never been implemented.
Okay. So M and S. So we had quite a discussion on mixed use as we were working on all this last year. So there is, so in parcel H, are there still businesses there, or what will be the criteria for having any multi-use criteria, or,
M&S allows commercial, allows residential, it allows a mix. There's no requirements in M&S to have multiple uses.
so not even, so I remember the discussion, like, is it on the floor, a bottom floor, or is it in a separate building, so there's neither requirement?
We have zones that do have that requirement, especially on arterial roads like Wadsworth and Kipling. On more minor roads or roads that don't necessarily want a ton of more traffic, we don't have that requirement to add additional uses.
Thank you.
While we're asking questions, will you, Claire, tell us for the record, what is the density limit for an M&S zone?
It's based on the height and the setbacks, so there's an envelope created. So, I mean, this is something that was spent a lot of time with in 2011, 2012 in how to create those density limits, and it's not done by units per acre for a reason, for a series of reasons that would take too much time to get into today. But density in Lakewood is controlled by a building envelope. So each property has setbacks and open space requirements and parking requirements and height requirements that limit the size of buildings that can be placed on them.
Thank you. And with regard to height and the LEED standards, which were first introduced in the 1990s, in case anyone wants to know the answer.
94.
What it allows is some changes to height in this case. So is what you're saying that the LEED standard and the city's desire to build more sustainably is what actually is driving the height here?
So exactly, in 2012, when this code was written, City Council had two things that they wanted to incentivize: affordable housing and sustainable buildings. And the incentive that they chose to offer for those things was an additional floor on any building in the city. And so it's not limited to base zones only. It applies to any zone in the city, including PD. So any new building that achieves one of those goals of the city council under the current code can add an extra floor for up to 12 feet.
Does this include houses?
Sure, I don't think it limits houses, but I've never had that question before. It's a high standard. It costs a little much to get LEED certification for it. It's, hundreds of thousands of dollars. So I think it effectively excludes houses.
Thank you. Board member Heald.
Thank you, Chairman Miller. My question is for Mrs. White. You mentioned just a while ago that the existence of two sets of standards does not create a conflict. It seems to me that we are here because of a conflict created by two sets of standards. Can you further explain why you have that position?
What I mean by that is, I believe, as explained by Mr. Parker, and when reading all the transcripts of all the dialogue around the adoption of the new zoning code in 2012, that the intention of the city in overlaying standard zone districts on top of existing PUDs was that the status quo would remain in place until such time as there was a market-based demand for redevelopment of all or a portion of the property. And when that redevelopment came forward, because the code explicitly allows you to choose which standards will be applicable to that redevelopment, there's not a conflict. Now, I guess there's a conflict as between what the neighbors think the standard should be and what my client thinks the standard should be. So we are in conflict. But the standard, like take height, as Mr. Parker said, the height limit in the ODP is 42 feet. And the code says in any zone district, you can add an extra 12 feet or 1 story to the height. So the proposed height here today is in compliance with both the ODP and the MNS code standard. There's no conflict. They can both be right. Anything else from you, Melissa?
Thank you.
Okay.
Why don't you sit down?
Thank you. Board member Bartlett.
Another question for Director Parker. We heard some consternation from the neighbors tonight about maybe the actual follow through on the LEED Gold standard from the developer. Can you maybe shed some light or summarize how the city ensures that a developer achieves those standards to meet that incentive?
Absolutely. So yeah, the city's put a lot of work and thought into this since 2012 when that incentive was added to the code. We actually have lead reviewers on retainer that work with us to review every project that comes in for LEED certification at each stage of the way. So yes, they don't get final certification until after the building's occupied, but there are milestones on every step of the way that they go through, from original design through construction plans, through construction itself. And we monitor that with outside help at every stage of the way to make sure that they're following, that they're meeting all the standards up to when we approve them and that they're following the direction.
Thank you.
I have a question for Mr. Silvestro. So I'm curious about the fact that the ODP identifies parcel H as having no density at all, and also as being commercial. And of course, the zoning was changed, and as Mr. Parker had explained, that all the commercial districts were removed, basically. So how would you see the ODP interpreting what should be done with that property?
So again, this is a point where we have tried to be reasonable, tried to sort of meet them halfway. The argument from Director Case originally, when he claims they're still proceeding on there, seems like the developer might have a different idea, is that the base zone is what allows them to ignore the ODP because the base zone added uses. We don't dispute that the base zone changed what you're looking at in this ODP. The city council said at the same time that it was reaffirming this ODP, we're adding base zones to all these properties. And what we're adding to this property is MNS. And the use that's allowed under MNS would include things beyond what you see here, business commercial for parcel H, including multifamily. And so again, our issue isn't with the use that they're trying to pursue. It's with the fact that they're trying to do it by completely voiding the ODP standards. And this is just a really critical, but ultimately sort of basic point. The uses tell you what you can do. The standards tell you how you can do it. The city's attorney explained, following the creation of these hybrid PB districts in 2012, what you ended up with was an overlay district in the ODP. So there were new uses added in, but the restrictions that were expressly retained by the city council, that were agreed to by the landowners back in 1982 and have never been amended, those continue to sit on top. The standards tell you how the uses can be brought forward. So we're not objecting to multifamily. We agree that that did change in 2012. The point on density is that the ODP is clear. It isn't parcel by parcel. It talks about, and Council for Crescent made this point, it talks about the zoning use at that time. But ultimately what it does is it sets a standard until change pursuant to the provisions of this development plan or as amended, which has never happened, that...
You're pointing at something I don't think we see.
Oh, I'm sorry. The highlighted language at the top of it.
Oh, I see.
Yeah, sorry. I appreciate that. Ultimately, the point here, and one of the public comments got right to this fact. All of the roads within the Wilson property ODP, and I don't know how many of you have been there or how recently, like Fence Farms.
Today.
Oh, great. The roads are extremely narrow. And, I think it's technically legal for parking to be on both sides. When that happens, you can really only get one car down the middle of those roads. And the point here is that the entire neighborhood is built out consistent with this ODP, which never envisioned more than a maximum of 380 dwelling units across the entire property.
I'm sorry about pressing on this, but I'm just trying to get this straight because I see it never envisioned any use for this parcel H other than commercial.
And frankly, I could probably come up with an argument that what the city council did in 2012 was not right. But again, that's not where we are. We're trying to be reasonable here. They did enact a provision that said we're adding new uses to this property, the whole area that's zoned MNS. That includes multifamily. And as I stand here in front of this board on behalf of my clients, we're willing to live with that so long as this new player to the game, the developer, comes in and adheres to the ODP, which puts a hard cap on the dwelling units within this property, given the specific context, the unique characteristics of these properties, which was expressly retained by the city council in 2012.
So we were just talking about lead standards and how, regardless of what the ODP.
I knew it was before I went to college because I learned about it in college.
And so in med school. So that's an example of where the ODP did not anticipate that sort of a standard. I don't think most people were at the time, but sure, it does allow. We could assume that it would accommodate those standards, correct?
So again, this is where we're really looking at apples versus oranges. The base zone provides a height, which is actually higher than 42 feet, it's 45 feet. And this is an overlay district that restricts that. It's a tighter standard that was retained by City Council in 2012 of 42 feet. Director Parker's point is that, well, the 12-foot adder applies across the whole city. There's nothing in this ODP, there's nothing in this overlay district that agrees with that. And LEED didn't exist in 1982, and I'll stipulate to that. But there's a way to amend an ODP that has never happened. LEED existed in 2012. If the city wanted to go to the property owners and figure out how to allow for denser development here, bigger building envelope, and that could have happened. It never happened. And so there is no variance, waiver, incentive, whatever you want to call it, under the ODP. If the ODP is not void, then 42 feet is the cap.
I'm having a hard time processing that, I'll tell you that, because in every other zone district in the city, as Mr. Parker was explaining, that if they were building to the LEED standard, they could use that. So you're saying that this one area would be an exception to that?
Well, that's what PDs are, they're exceptions. It's an overlay district that the city council explicitly retained in 2012, saying in this area, we're gonna add uses, but the standards that have been in place since 1982 are gonna stay here.
Okay, thank you.
Thank you.
We have some more questions, here. Some of them may be for you. Is that-
I'll just,
While you're
I
there.
can't, I probably should forbear this kind of question, but I can't resist it. Are you arguing that an ODP creates kind of a super ordinance? Can you elaborate on that? That it seems like somehow ordinances can be repealed, revised, so forth. ODPs require something else?
Well, I can argue it both ways.
Okay.
In 2012, the city council retained this ODP. That was an act of the city's legislature. It's not a super ordinance, it's an ordinance. The other piece of this is that going back to 1982, this is a private agreement between all the landowners that binds their successors and can be enforced by those private landowners. So if the city is intent on removing this overlay district, which they didn't do in 2012, I would hope they would want to engage with all of those landowners. And, you know, there's a lot of paper that's kind of buried in there, but this is the point that I was really trying to get with, referencing Mr. Cox's statement from the July city council meeting. If you turn to item 19, there's a discussion from that city council meeting, different context, but talking about how the city governs land uses. And at that hearing, there was someone subject to an ODP that was seeking to rezone their property out of the ODP. And the statement from Mr. Cox was that when the city does that, when it changes ODP standards that affect neighbors, the city gets the consent of the neighbors. And that's never happened here.
Okay, thank you.
Board member Heald.
Thank you. This question is for you, Mr. Silvestro. Kind of a follow-up to Chairman Miller's question about the interaction of base zoning, underlying zoning, and the ODP. So what you're saying is that because this parcel didn't have specified uses, that the underlying zoning, the base zoning would now define the uses. And you're saying that the stipulations in the ODP would control the amount of those uses, the application of those uses. Is that correct?
Yeah, I think that's the only way to reconcile what the city council did in 2012 by
So-
doing this.
Okay, so in this case, the proposal for multifamily would be valid under the MNS, but it would be limited to the total number of dwelling units under the ODP. Is that right?
ODP standard governs the use that's now allowed as of 2012.
Okay, so that's where the number cap would come from, the ODP, right?
Yes.
Okay, so that kind of, I appreciate that clarification, because with two types of information to provide the guidance here, it's really critical how that interaction works, so I would be clarified. Thank you.
Yeah, and if I might, just momentarily, ultimately I'd go back to the interpretive tool that we highlighted at the very beginning, which is if the city council did something that maybe they didn't think through all the unintended consequences, and you have two provisions that just don't work together, the code tells you, the city council told you what to do. The more restrictive provision prevails.
You might wait just a moment. We have some other questions, but since we're on that, it's still not clear to me, if you stay on that screen, which was this one, this is part of the ODP, right? And it actually specifically says parcel H, no no housing units. So does this mean that the ODP has been modified? Because it's, I mean, I'm not sure how you're understanding that, interpreting how we're supposed to understand that we accept that there's a new zone applied to parcel H, but that we're keeping some parts that actually don't even seem to be listed there. Can you explain that to me?
Well, I think what we're all trying to do is figure out what the city council had in mind in 2012. And so they're the ones.
Read their minds, you
know? Yeah. We've got the legislative history to the extent it exists, and we have Director Parker's statement saying that, you know, it was a misconception that anyone would think these PDs were going away because not a single word was going to change. So those are the instructions we have from the past. With regard to this specific provision and how we reconcile an ODP standard that hasn't changed with uses that have changed, because now there's, you know, I think we're making this up as we go because maybe the city council was, they've created an underlay zone. And now you have an overlay land use standard. So by making this MNS, the city council decided in 2012 that this could be multifamily. And that's not something we're disputing because, again, we don't want to get bogged down into allowable uses. And frankly, we just want to be good neighbors and work with someone who's, you know, hopefully going to do something that fits within the character of the neighborhood, but actually do something valuable with the property. So at the end of the day, all we're trying to do is make sure that the ODP land use standards remain in effect. You know, not even just for this case, but the precedential effect that could have beyond this case. And so when we look at the total maximum number of dwelling units that are allowed within the property, and again, this is about the unique characteristics and the context-sensitive issues that the city council was trying to preserve in 2012 by preserving this ODP. This property can't handle more than 380 dwelling units. And I say this property, the entire Wilson property, that's subject to the ODP.
Does the ODP address redevelopment?
There's the one discussion that Councilor Crescent has talked about, the idea that the northeast corner would become more dense and that somehow that would migrate to the southwest. It does not provide any level of specificity that I think is helpful.
Does the Lakewood ordinance address what standard we should follow in the case where an ODP does not define a situation?
The only thing that I can go back to is the standard, that the provision that says if you have a rule that conflicts with another rule, and you know all these rules were adopted in 2012, so there's not like a last in time issue.
Well, I get that, but I thought we were just I was just stating that there didn't seem to be a rule. That's
right. All I can point to is the tiebreaker is the more restrictive provision.
That's your contention, you're saying?
That's in the code explicitly. So this is 17.162A, quote, where any regulation, requirement, or condition imposed by any provision of the zoning ordinance conflicts with any other regulation, requirement, or law, the provision which is more restrictive or which imposes a higher standard or requirement shall govern.
Thank you, unless, don't leave yet, because, okay, thanks. Board member Sinks.
Thank you. So Mr. Silvestro just referred to some things that Tim Cox, our attorney, said back in August, item 19. And so I found it and it says, quote, what I'm referring to is what's being changed. You can change an ODP so that every parcel is directly or indirectly affected, and it keeps going, end of quote. And so, Mr. Cox, my question is, it says, you can change an ODP. And so who's the you? Because Mr. Silvestro just said that no owner's ever been asked. You know, there's never been any discussion about that. So you can change. Who's the you? Is it?
If we're talking about an amendment to an existing ODP, that's done through the same zoning process through the city council and planning commission as any other rezone.
Great. And so by virtue of the city council being elected by the citizens, then that's kind of an indirect citizen permission given to the city council to represent them, and they can change.
Well, the function of the city council is to represent the various wards within the city and the people within them, and to the best of their ability, not to represent each individual resident, but to attempt to carry out the interests of the residents, yeah.
Thank you.
Board Member Cohen.
No, I don't know that I have asked to speak.
Okay.
So I think I've pretty well exhausted
You always want to know what you have to say. I have another follow-up question. This is Mr. Silvestro. You had referred to another, so I may come back up actually, if you wouldn't mind. You had mentioned in your presentation at the beginning that I believe I listed under interpretive tools, we were looking at ordinance 17.1.6.2C. Which I'll just read it. Not the intent of this zoning ordinance to interfere with, abrogate, or annul any easement, covenant, deed restriction, or other agreement between private parties. That's what you were asserting. It goes on to say, if the provisions of this zoning ordinance impose a greater restriction than imposed by an easement, covenant, deed restriction, or other private agreement, the provisions of this zoning ordinance control that seems to conflict with what you were saying earlier.
Give like the first sentence of this section.
It looks like you were, yes, that's what happened. Like you were, what's showing here, section 17.1.6. I'm sorry, 17.1.6.2C is not the complete ordinance. There is another sentence there. That's what I just read. If the provisions of the zoning ordinance impose a greater restriction than imposed by an easement, covenant, deed restriction, or other private agreement, the provisions of this zoning ordinance controls.
Oh, yeah, sorry, that wasn't included because I'm not sure that it applies. That would be in a situation where two neighbors say, you know, we're not gonna operate a bar that goes past 10 p.m., but, oh, wait a minute, the zoning actually doesn't allow for a bar to be at these properties at all. In which case, then yes, the government regulation would supersede the private agreement. What we have here is the flip side. We have a private agreement that's more restrictive.
Well, they're listing them as easement, covenant, deed restriction, or other agreement between private parties. I think that was the way you've been describing the ODP as an agreement between private parties.
Right, that's more restrictive than government regulation.
Well, this, what I'm reading here, and that's why I'm concerned that you only provided half of this section of the code, is the rest that actually says in the case where the zoning ordinance is more restrictive, that it goes with the zoning ordinance.
Right, that's not happening here, so I'm missing why that applies.
Well, I'm not sure then why you listed this one at all. If you're not.
So there's two sides of the coin.
I guess I'm not clear about how it doesn't apply.
There's two sides of the coin, right? There's a circumstance where a private agreement is more restrictive than government regulation. That's the first sentence.
No,
It is not the intent of this zoning ordinance to interfere with or abrogate or annul any easement or covenant, deed restriction, or other agreement between private parties. However, this is the second
That
sentence.
doesn't address restrictive more or less. It's just, is, I think, identifying what we're talking about, correct?
Sure, and then but the second sentence is saying if regulation goes beyond those agreements, then the agreement has to yield to the more restrictive regulation.
No, that's not what it says. It says if the provisions of the zoning ordinance impose a greater restriction than imposed by an easement, covenant, deed restriction, or other private agreement, the provisions of the zoning ordinance control.
And so are you saying that's what's happening here?
Well, I'm asking, I guess one thing I'm asking is why we didn't see all the text of that portion of the code. But secondly, I'm asking, it seems to conflict with some of the things that you were saying, so I'm not clear.
Well, so in all honesty, I didn't think it applied, and maybe we just have a misunderstanding about that, or I'm missing something. The second sentence says, if the zoning ordinance imposes a greater restriction, then the zoning ordinance is still gonna apply. And again, if you and I are neighbors and we say, well, your bar can't operate past 10 p.m., but the zoning doesn't allow for a bar, then our agreement doesn't win out, the city regulation wins out. And so, again, it is an honest mistake. I wasn't trying to stake anybody, certainly. I think the importance of the first sentence isn't changed by the second sentence, which is if two neighbors, so you have a restrictive easement that says, restrictive covenants on an HOA say nothing in this neighborhood can be used for anything but single family residential. The city can come along and put MNS zoning on those properties, and it's still going to be the more restrictive private covenant that controls.
Okay, I see, that's your contention, I see, okay, thank you. I would, that's all. I would ask the applicant, Ms. White, if you would. If you would comment on the same section of the code, one part of it, and then I assume you have it. Okay.
I do.
Does that apply here?
Our position would be that neither the sentence shown on the screen nor the second sentence really applies, because we're not talking about an easement, covenant, deed restriction, or other agreement between private parties. We're talking about a zoning document created by the city, which the city can change or modify or supersede through its own legislative authority, and which in fact it has done so through the zoning code it adopted in 2012. So I actually think this whole section doesn't apply here, because we're not talking about a private covenant, deed restriction, or other agreement between private parties. But to the point of whether or not there's something in the ODP versus the zoning code that's more restrictive, I would actually point out that our discussion about architectural review, in my view, the zoning code is more restrictive than the ODP when it comes to architectural review. And we explained this in our letter, but here's why. In the ODP, what it says about architectural review is, thou shalt submit thy plans to an architectural review committee, which doesn't exist. In the zoning code, what it says about architectural review is 20 pages of very specific performance standards that staff is supposed to use to judge the architecture of any proposed site plan. And that includes things like materials, building facades, articulations, interaction of the pedestrian space, transparency at ground level, pedestrian circulation, and a whole host of other things. And so in that regard, the architectural review provided by the zoning code, which is what the staff rightly chose to use in this case, is actually far more restrictive than any allusion to architectural review in the ODP. But regardless of that, the ODP is not a easement, covenant, deed restriction, or other agreement between private parties that would trigger this section in our view.
Thank you. That's for right now, and I want to follow up with the city's council, if you wouldn't mind.
Same question?
Same question. I'm curious how the city uses.
I agree the same way. I mean, HOAs create covenants, and sometimes they're more restrictive than the city zoning document, and that's fine. We don't get in the way of them enforcing those covenants. We focus on the zoning, and our zoning doesn't negate their ability to create and enforce their own covenants, but that's not what we have here. We have a zone district, and it's my job and your job to interpret that zone district. And we're not talking about other covenants.
Okay. Thank you. Thanks to all three of you. I don't know who that's first, but board member Stone.
You've answered my question. I have the same question.
Oh. Board member Sinks.
So I just have a quick question. So Crescent Communities is not the owner of this property, correct?
That's a short answer. Can I answer from here?
Yes. Mr. Chairman, no, they are under contract to purchase the property at the present time.
Okay. And it, so I imagine it's contingent upon what happens with the project.
Mr. Chairman, board member saying it's not really appropriate for me to discuss the terms of that contract in this public forum. I'm sorry.
That's okay. Thank you.
So, do it again. I have another question, starting with you, Mr. Silvestro. Thank you. So this is about another portion of the code that everyone's been talking about. This is 17.3.6.5. And section A, I'll let you get there.
Yes.
So, this section A says redevelopment within a PD district may apply either the standards of the base zone district or the standards of the ODP. Can you tell me what your position on that is?
Sure, redevelopment is not defined anywhere in the zoning ordinance. And so Director Parker has decided that this is a redevelopment. But there's no way to read that provision consistent with what the city code did in 2012 by retaining this ODP, because essentially they shouldn't have done that. It's avoidable. And you know, there's just a basic principle of legal interpretation that every word, every action should have some meaning. That we don't assume that the city council just did something and it wasn't intended to have any actual meaning. And so the only way for this other standards provision to make any sense is if redevelopment requires something more than simply building on to one building on less than 10% of the whole property. I mean, the logical fallacy, you just sort of play out the argument. So their argument is that all of my clients are bound by the ODP, right? Because they're not redeveloping their properties. But anybody new who comes in, from out of state with money, whatever, they're not subject to this document that's been in place since 1982.
So you said that redevelopment as a term is not defined here. You also said that redevelopment is not addressed in the ODP, correct?
Not specifically.
Okay. Thank you. And I would ask Ms. White if you would come forward. Thank you very much. You didn't get your cardio in today, you're getting in now.
According to my watch, I need to stand at least once every hour, so thanks for
You're
giving me a
welcome.
chance. If I may, sir, we actually have a slide in our packet on this topic, so if I can bring it up for your question.
Sure, we've been showing the appellant slides, we'll show yours.
Your question, or do you want me to just answer the same question that you asked Mr.
You can start there, and if you want to expand also, you can.
Yes. Well, it is our position that the proposal to redevelop the White Fence Farm former restaurant into a multifamily apartment use is in fact a redevelopment as that term is defined once was defined in your zoning code and any zoning code and any dictionary. In other words, redevelopment meaning it was once developed and now it's going to be developed again into something new and different. But if we're looking for some specific definitions, the first definition on the screen is one that was in your prior zoning ordinance before you adopted the new zoning ordinance in 2012. I don't know why the definitions section was revamped the way it was. Maybe we could ask staff about that, but I couldn't find this definition in the current code, but this was the definition in Lakewood up until 2012. And then a couple of common dictionary definitions. I mean, I think it's pretty clear this is not a new development on vacant ground which has never been developed. There is an existing building there, and in fact, we intend to adaptively reuse it, as was advocated for by many of the neighbors in some of those initial meetings. So there's certainly no question in my mind that what is proposed here is redevelopment. And if there's no basis for using these definitions to decide what redevelopment is, there's certainly no basis for deciding that redevelopment only means the entirety of all of the property that was included in the original ODP, which is how Mr. Silvestro suggested the term redevelopment should be read in this provision. But I'm glad that you focused on section 17.3.6.5A, because in our view, that really is the critical piece here, and it's really dispositive of all of the issues before you. That section, 17.6.3.5A, clearly says redevelopment in a PD may use either the standards of the PD or the underlying town district. There is a choice, and that choice was properly exercised by both the applicant and Mr. Parker in this case. And this question of conflict and what's more restrictive and whether or not there's a restrictive covenant, all of that really doesn't even come into play because the question is answered by that section 17.3.6.5A.
Thank you. Mr. Parker.
Unfortunately, I have the burden of having written this particular sentence. And the intent was not that the entire PD has to be redeveloped. The word within was included to mean, any portion of a PD certainly meets that standard. The thought at the time here was, and the discussion with council was, there were developments created under planned developments. And those developments in a lot of cases still exist. And so we need the rules to stay in place for the life of that development. Though we don't want to change the rules for a development that's in place. However, the council in 2012 didn't want to prejudice future redevelopment with those old rules. Those old rules were written for a specific building or set of buildings in every case, and those rules needed to stay in place for that specific building or set of buildings. When those buildings were removed and a new development took place, a redevelopment of that property, the intent was those old rules no longer applied. That was the purpose of this section for exactly the situation we're here tonight. An old building has outlived its usefulness and is being demolished, and a new development is taking place. And so the rules written in 1982 for this specific parcel were no longer meant to apply by the council.
You were just saying that you specifically intended that it meant a portion of a PD. And there's a certain amount of common sense that we want to apply to some of these things, like the definition of redevelopment, if we no longer have it in the code, for instance. So was that an omission in the process, or is this a term that's so common that we don't need to define it?
It certainly wasn't there wasn't any intention that I'm aware of leaving it in or taking it out. It was may be seen as common enough. I know that when the new code was written, staff scrubbed it for terms that seemed to ask for definition, and we defined those terms that we thought needed to be defined, and this is potentially one we missed or one that was assumed was common enough.
I'm trying to assert that you missed it, I was just asking, it's part of the process. So, I have one more question. Could lead to another one, but I don't know if everyone this could happen. We should probably start with this. So it's really in the same section, and it's the introduction to that section, standards. All right, take it back. 17.3.6.5, the standards of the applicable base zone district or districts included in the PD as identified in this zoning ordinance shall apply to the PD district unless specifically modified as a part of the PD. Any modification to the standards shall be identified as part of the ODP. So I'm wondering, when the new district was created, the MNS district for this parcel H, does this suggest that the people who are managing, owning the ODP should have addressed some of these issues in that parcel?
Well, I think that the city council did that. So unless specifically modified as part of the PD, when the city council essentially brought this ODP over into the new regime, the city council was saying there's a new base zone at this property and the overlay district is going to continue to function with regards to the standards of those uses. So I think part of the confusion here is that the code was trying to be written to both deal with old PDs and allow for the possibility of new PDs in the future. That's not what was happening here. Our case is the first one. They were bringing a PD over, adding an underlay base zone and saying, you know, the base zone standards apply except to the extent they're modified by a PD. Exactly what's happening here.
Of course, the PD doesn't actually address an MNS standard. It doesn't even address density for parcel H.
Well, it addresses standards on allowable uses within the entire parcel. And so that's exactly what this is speaking to, standards. PD does exactly that. And again, I don't mean to besmirch anyone's character, but in 2012, when it was actually happening, Director Parker specifically, this is tab 23 in the packet, specifically addressed what he called a misconception that all PDs were going away. And he said, what you're doing here with the PDs that you're retaining is not changing a single word.
Mm-hmm. Okay, thank you. Do you have anything you wanted to add? Mrs. White? No, I don't want to mix up the order and confuse people.
Okay, all right.
Yes. I think the difference here is that when City Council adopted the new zoning code in 2012 and they rezoned the whole city, they did not change the Wilson area. They adopted a set of additional standards which could be applied to the ODP in a specific circumstance. So, for example, when you were quoting Mr. Cox earlier in his testimony in 2012 when he spoke, or most recently in 2019, when he spoke to an amendment of another ODP, that was a specific amendment to that ODP. What happened in 2012 was a citywide legislative adoption of a new code and a set of standards which under certain circumstances might be applied in exactly the way we're talking about tonight or might not. So nobody changed any words of the ODP and nobody's consent was required for City Council to do what they did in 2012. But they set the stage by creating this scenario where there's this other set of standards which could in certain circumstances be applied. And, you know, fast forward the videotape, that's where we are today. But No one changed the ODP then, and no one's changing the ODP now. The ODP stays the same. It is what it is. What we're saying is, here's another set of standards that might also apply. And lo and behold, we happen to have the set of circumstances before us right now where that has happened.
Thank you. Mr. Parker, did you want to add anything to this? I mean, I think I've addressed this issue. Okay, that's fine. Any other, so there's no other board member questions. We're going to take a 15-minute break. When we come back, we will allow time for rebuttal. We're going to allow 10 minutes for each of the three parties. So this will give you a minute, 15 minutes, in fact, to collect your thoughts. Thank you.
Well, 11 o'clock.
How you doing?
How are you?
You won't make 10 copies.
I was in the direct line of the camera the whole time. I was thinking, oh, I finally hid behind that wall. Running away.
It has the 4 batteries. They have a plug in it, and it's like a horseshoe in it. Does that fit it just USB? Is it plugged into a wall? It says 1.5 volt. I go through the batteries. 2 hours.
Stretching also voice.
Well, I can't hold my computer. What's going to be involved? My computer. It's supposed to be. Okay, I have exercise at 8 o'clock. Well, I've got another pack. So you're going to Zoom call? Okay, I'll get up for that. All right. I'm not really sure. But it's getting me 3 hours. But that camera, guys, and they're not returned. No. Even them, they go out now. It looks like that horseshoe one reach yeah, the connection's got horseshoe. I think it might be a little bit more tech savvy and neat since it's completely.
by horseshoe, old style, like old flash style. So you can like store it.
No, it's got a horseshoe. It looks like a horseshoe.
So you can like
No, it's just one of same size that I would plug into this. But it's still, it's a horseshoe.
Yeah, I think that's it now. Here's the name.
You're not that tech savvy.
In the hospital, I used to be that you can have like
Now I'm trying to say.
Oh, yeah.
I want to.
And, I didn't know
I don't know.
So set your alarm. You have a doctor's appointment with Dr. Hurt.
We'll see.
Set your alarm.
I'm here to put him in. So he paid land.
Oh, yeah, they're looking.
I upgraded it. But I got the flat surface.
Yeah, when you get into the 200 meetings, then suddenly we're so.
I don't like it also because I didn't have the these last probably still sit on maybe a day. I don't want
No, that one, that Baptist one, you've seen, yeah. And he wants to see if it's that, we'll go down, go west. It's always something. Oh, west, Did you even get anything? No, I was just putting two and two together. Because I didn't know. No. Barb comes and Brian. Yeah. So what ended up happening is I went over to some place. And then we got World Estates. So that's how that 11 came together. So everybody's got the same questions. So that's good. The bar they were there. They're speaking white anyway, I was a little surprised to watch it. Yeah. So that's the other thing. No, I'm sorry. Oh, shoot. Okay. No, listen to no, I think they are getting so I don't know if they posted or not, but I can put you on the list. You can do whatever you do. It's just so frustrating. Okay, great. Okay, so my name's Liz. Good to meet you. Yeah, so we're in. Get that out. Cool. I gotta get going. I know. Well, it's not 2:00 yet. We're normally here till at least midnight. Anyway, good to meet you. Okay, we'll talk later. I was thinking it's better because it feels good. Oh no. Well, that was my request to that from the developer. For more than 3 shared it to Lakewood. Should they do it? No, because I was being told about that was something they were going to do. But that was in one of our requests.
Because you know those things, if you hit at least 10.
Oh, I know. It's 3 years. 3 years. I said it 3 years. Jewel. Sitting over here in traffic engineering. Yep. 3 years. But also, there's some great police officers who I've become friends with. I don't know if you have tickets or not, but I've never been to. But you had to have them too. You had to have their reference saying, you know what, people are driving out by here crazy and they're doing this and they're doing it. Yeah, with the yeah, well, I'm telling you, it took 3 years for that to happen. Yep, I will take credit for that. I'm sorry, I will take credit for that. But again, because there's some really great people that are finally found over there, but I had to have the police officers also back us up because it can't just be the citizens who are saying, oh my God, they got to. It's also the police officers who know darn fast they're driving to the meeting. What we explained about in the drag race. And the officers go, show up. Well, they show up. I don't understand. Yeah, they show up. They show up. The other night was spoke to this. He was just talking about this Monday night, and I said, I understand. That's because they're sitting up here. He's trying to cross like near elevated apartment. He's trying to walk across the area. And it's bottom line, Mike can tell you, he heard the guy. And he said, no, I'm taking this here. And I came, oh, and really got hit. And so then my kid then says, I know it's old other consumer. These, I mean, right away you're going, but there is a whole crew on board. So they're just going to sort of finish it up. So then, 2 weeks ago, when I was watching them downstairs in the basement, and they were all doing different things. So once they get all over, there's an awful lot of places they got to be. I mean, in our neighborhood alone, we got enough junk to last us a lifetime. Oh! You want some? No. Which one was it, Mike? Oh, yes. Yes. Yeah. Pardon me. Thank you. We're out here, should make sure you're taping. I'm not going to get one place to be. Well, hopefully just nobody's going to bail you out, Good question. Sometimes that happens.
Makes a better door in the window, don't it?
Are you ready?
We'll come back into session. First, order of business, this may have been an oversight on our part. Mr. Krasnow, who provided some answers, some questions earlier. Yes, sir. I don't believe you were sworn in. Is that correct?
That is correct.
Okay. We'd like to do that now.
Do you swear that any testimony you give tonight is the truth?
Good. Thank you. It's all right for us to do that after the fact.
I'm not sure you have to be sworn to begin with, but just cover it. Testify if you told the truth.
Thank you. So we will proceed with rebuttal, 10 minutes each, please. And look at my notes to see what order we get to hear from each of you. Do you know? That's good. I'm glad you prepared for this.
You indicate the city planning director first, then the applicant developer, and then the appellant.
Thank you. I lost my note. I'm sorry. Thank you. Please.
You have an incredibly hard job tonight of interpreting and enforcing the zoning ordinance. I know because I have that job every day. And There is not a decision that's made by the planning staff that doesn't inconvenience or upset someone. Either a property owner who wants to do something they can't, or neighbors who don't like what's happening near them. And that is our life as enforcers and interpreters of this zoning code. And tonight you get to share in that joyful exercise. It's difficult, especially because sort of we understand the issues involved. I have a lot of friends in this room and in that neighborhood who I see up the community and who I see at the link and who I meet with regularly on this project and other projects, and we work together well. So I certainly understand the concerns with the new development, the change that's coming to the neighborhood, how the building will be taller than its surroundings and may not be as compatible as we'd like with the neighboring homes and the neighboring buildings, and may not fit as well as we'd like with the existing structures that are there. Unfortunately, I don't have the discretion and the power and this ability to subjectively review these projects that it is often made to seem that I have. And the planning department itself is built around reviewing objective regulations. One of the principal pieces that we wrote into this code that we worked closely with council on was making the regulations as objective as possible. And that takes away a lot of ability for planning staff and you and others to say, well, the regulations say this, but the development would be a lot better if. The development would be a lot better if they dropped that fourth story. The development would be a lot better if they moved it further south, right? And these are true. And it would be nice if, in some ways, it would be nice if we collectively had the ability to make some of those changes. But the flip side of that is the misuse of that power, the abuse of that power, and the inconsistency of regulating that way and taking each development and making it political, making it subjective, and doing things in an inconsistent way. And our council in 2012 wrote a very objective code, and they wrote one that did not provide discretionary power. They put that intent statement up front that said, we want this code to be consistent with the comp plan, and we want it to accomplish these things. And we all collectively, planning staff and the community and the council, try to write a code that put the regulations in place and map them in such places that would accomplish those goals, but didn't add power to say, we can change those regulations within those districts where we've got a little wall, right? And so that's the position that we're in. That's the position that planning staff's in, and unfortunately, that's the position I think you all are in, where we have some very clear statements in code about what can and cannot be done on this property. And we have there are certainly confusions. There are certainly areas that can be looked at in different ways, and that can be confusing. But certainly the crux of the issue is the section that we talked about at the very end, the redevelopment section, right? Planning staff didn't even start that way. We tried to review this and will continue based on your ruling tonight under the ODP, applying as many rules of the ODP as we could. So the 42 feet height going up to 54 feet rather than the 45 feet going up to 57 feet, right? We looked at this under the regulations of the ODP and tried to make it work under those regulations. However, if that doesn't work, I don't have the authority, my staff doesn't have the authority to prevent the applicant from coming in and saying, we want this reviewed under the MNS zone, right? That authority doesn't exist. That statement is very clear. Redevelopment within a PD may. Doesn't say the planning director gets to choose and apply which one he wants, or planning staff, or even planning commission or board of adjustment. It says the redevelopment may do this, and the property owner is redeveloping the property. I, quite frankly, we crafted that statement the best we could to achieve the goal of phasing out old ODPs once they were past their useful life. And that was the intent of that statement for these situations where redevelopment was occurring and was meant to occur under the base zone that occurred. We can keep, these things around, we can, and if we can make them work, we should, and that's what we try to do. But the authority exists in the regulations not to. And that's the crux of the issue. The other three issues, we can resolve those, we can talk about height, we can talk about residential density, we can talk about the architectural control committee, but all those become moot the second a property owner says, I'm redeveloping and I want to use that base zone. Right? So that's the crux of the issue tonight, is that maybe that language could be more clear, but it's certainly clear enough at the intent. There are no alternate definitions of redevelopment. Old development's gone away. If it's not a green site, new development's coming. There's certainly clarity for the word within a PD, as opposed to the entirety of the PD, right? May apply this or that standard. Not shall apply one, not, may apply the most restrictive, may apply either or. It was intended for this very situation. Certainly I can address and will the other three. We've talked about the height, right? There are general statements in our zoning code that apply across the board. There are rules for how you measure setbacks. Those don't just apply to base zones. They apply to how you measure from the property line or from the back of curb. That's a general rule. It applies whatever your zone is. This is one of those. The incentives put in by council, they apply regardless of zone. A PD isn't exempt. A particular zone district isn't exempt. PDs are subject to the general rules of our zoning ordinance. The whole standard versus use argument in the code, that particular property or that particular parcel, as I said before, it allows under the ODP for 0 residential units. Prior to 2012, we would have allowed 0 residential units on this. Council chose to allow residential and limit it by its building envelope rather than by its number of units. And that's how we do things now. We have other planned developments in the city that have density caps on them. Those aren't used anymore. We've got one in Solterre, Belmont, we've got other PDs with those, and that's not how it's been used since council changed the rules in 2012. And quite frankly, that would change a lot of precedent for how we've done business in the city since 2012. And then finally, the Architectural Control Committee. We can't go back and retroactively apply rules. As I said, those ODPs that contain architectural control committees, they have full approval authority over the architecture, not the other standards in the code of developments that come before them. But you can't go back and change the rules after something's applied. So future developments, if an architectural control committee is in place, that will apply. But we can't go back and change the rules retroactively to make that apply on businesses. So I remain available to answer your questions, but the crux of the issue is that this section about redevelopment, and we're happy to continue reviewing under the ODP. But the second the applicant asks us not to, we don't have the authority to say no to that. Thank you.
Thank you. Thanks for observing your 10 minutes.
Mr. Chairman, members of the board, Carolyn White, Land Use Counsel for the applicant. For the first minute or two, I want to briefly just start by trying to answer the question that was asked earlier, because I do now have the answer in front of me. Well, one question is, LEED was adopted in 1998, just so you know. But I wanted to answer the question about whether or not concessions were offered and were in fact made with this project. And Although I don't think it's directly relevant to the question before us tonight, I don't want to not answer that question. And so I want to let the board know, first of all, that the original proposal was 260 units. That was reduced to 234 units, and that was what was actually submitted, even though no agreement was actually ultimately reached. So the reduction in units was a concession that actually happened. And then there were a number of other concessions that were proposed in that MOU that went back and forth, including lease restrictions in each and every lease that would provide no resident street parking, no visitor street parking, restrictions on cleanup of waste from pets, tenant head count, restrictions on the percentage of units that could ever be leased below market rate, restrictions on landscaping, maintenance, and all of this would in fact have been a covenant that ran with the land and was intended to be recorded against the property, but it never did happen. But so just to address your question about what those concessions were, that's a rough list of what they were. So now to our sort of concluding statement and our rebuttal. In this appeal, the HOA's position is that City Council can add uses to the ODP without asking their permission, but they can't add density to the ODP without asking their permission. And those two things can't both be true under any proper legal interpretation of City Council's authority. I want to just skip to the right slide to match here what I'm going to say, and then I'll. All right, so the question before you isn't the same as when you're wearing your planning commission hats, even though we know that you all serve as planning commissioners as well, and thank you for that double duty. The question isn't, how are we gonna make this project compatible with the neighborhood? Do we like the neighborhood proposal better than the developer's proposal? Do we like the architecture of the project? Those are not the questions before you tonight. The question before you tonight is only, was Mr. Parker's interpretation in his letter correct and lawful and proper or not? And that's the question that we want you to answer. And all you need to know to answer that question is right here on this screen, and it's contained in section 17.3.6.5. The question is, should we, wherever appropriate, and as requested by the applicant under this provision, as was just explained to you by Mr. Parker, apply the more current, modern, progressive, and sophisticated standards adopted by City Council in 2012 when they rezoned the entire city and adopted the new zoning code? Or should we attempt to apply old, obsolete, and in many cases inapplicable standards from an old 1982 PUD zoning document? And so taking each of those three things separately, density, height, and architectural standards. Speaking first about density. There are a variety of ways to interpret what the ODP says about density. It's either silent or it provides no limitation on density on parcel H. Mr. Silvestro says that you have to take the whole density for the whole area and subtract out what might be remaining. But then also says that density cannot be added without getting the permission of the other property owners who are in the ODP. But the way that the new code calculates density is not by just limiting some numerical standard. And as Mr. Parker was just explaining, there's not a 8 dwelling units per acre or Y dwelling units total on this parcel. That's a very absolute and inflexible way to measure density. The way the new code measures density is by saying, here's all the performance standards you have to meet. Here's the maximum height, here's the setbacks, here's the open space, here's the land dedications required. And within that building envelope, whatever fits, that is the limit on density. That's the way the new code measures density. So it's not correct to say that there is no standard in the new code for density. There is, and that's the standard I just described, and that's the analysis that was performed here, and that is the appropriate analysis to put, to apply to this application under the MNS underlying or overlying, however we want to look at it, zone district. Speaking about the height, I think that's been addressed in great detail, and it doesn't really matter whether you look at the code standard for height, 45, or the ODP standard for height, 42. Either way, the lead incentive to add 1 story or 12 feet applies to all zone districts in the city, PUD or otherwise. And so the proposed height, 54 feet, is within the maximum limit, whether you look at it under the ODP or the MNS zoning. And so that determination by Mr. Parker that the proposed height was within the allowed height is absolutely correct, whether you think it should be under the ODP or whether you think it should be under the MNS district. And then finally, the architectural standards, the architectural review. And I had the chance to speak about that a little bit earlier in response to a question. I want to just maybe emphasize that a little bit more by noting that the ODP itself only says you submit your plans in for architectural review, period. It doesn't say who's on the architectural committee, how they get appointed, whether one HOA controls it or the other 3 HOAs control it, how they get removed, what the standards of review are, when their meetings are held. There is no information whatsoever about that architectural control committee. By contrast, the code, as I pointed out earlier, has 20 pages of very detailed architectural standards that apply, again, in all zone districts. Those are the architectural standards for review regardless. And therefore, it is absolutely appropriate for the city to say, in the absence of an architectural committee, and just like we have with many other similarly situated ODPs, where there is not and never has been an architectural committee, we're instead going to use the MNS standards and review the project under those very detailed architectural performance standards in the new 2012 code. You've received a great deal of information this evening in your packets. We've written you a number of letters. Staff has written a number of letters. Mr. Silvestro has written a lot of letters. You've heard a lot of feedback from the neighborhood groups. Really, everything you need to know to answer this question is right there on the screen. It's 17.3.6.5A. Redevelopment within a PD district may apply either the standards of the base zone district or the standards of the ODP. It doesn't say that you can apply either zone district so long as everyone is in agreement, so long as there is no conflict, so long as none of the neighbors object, so long as you get the permission of all of the neighbors in the ODP. It doesn't say any of that. It just says you may apply either standard, period. And that is fundamentally the answer to the question before you tonight. Just briefly, I want to talk about the covenant issue, since we spent a fair bit of time on that tonight. Mr. Silvestro has told you that the city cannot make any changes to the zoning code or make any changes that might affect how the ODP gets interpreted without seeking the consent of the property owners, because the ODP constitutes a contract or a covenant or some other binding agreement by and among private property owners. It is not a covenant. It is a zoning document adopted by the city pursuant to the city's legislative authority. It can be rescinded, amended, changed, or superseded by the city council through its legislative powers. Believe me, there are many times when I have been representing property owners, and I wish that were not true, but it is the law and it is how zoning works. And there's really nothing that evidences any type of agreement by city council to agree not to exercise those powers when they approve the ODP, notwithstanding the fact that there's this language in there that says property owners have the right to enforce it against subsequent property owners. They may indeed have that right, and if we're going to have that argument, we certainly can do so in a district court, not in this forum, as was referenced by the Q&A. We can debate whether or not that language creates a covenant. My legal opinion is that it does not in and of itself, particularly in a document that is not between private parties and is not recorded against the property. But it's neither here nor there, because ultimately the question before you is, were these standards properly applied? And the answer again is right here on the screen. Yes, they were. You can choose either or. So there's really no reason that Mr. Parker's decision.
Close to the end.
Okay, that's my last sentence. There's no reason Mr. Parker's decision shouldn't be upheld, except that the neighbors don't agree with it. And that's not a valid legal reason to do so. We therefore ask you to uphold Mr. Parker's decision. Thank you.
Thank you. And thanks for observing our 10-minute limit.
Thank you, and thank you to the board for giving me the last word. It's 6 against 1, so I appreciate this final opportunity. I'll pick it up right where Ms. White finished. If Director Parker's interpretation is correct, then every ODP in this city is meaningless. Every single one. Redevelopment means that you build something onto your property. Any one of these single-family homeowners can sell out to a multifamily developer, and all of a sudden there's no density. We got to deal with the envelope, but it's a free-for-all. And maybe that's okay, except what about all their single-family neighbors that are stuck with their properties, that bought in with this ODP recorded against property? And Ms. White said earlier that this wasn't recorded against parcel H. That's unfortunately, for her argument, not true. Item 3 in your packet includes the recorder's certificate from when the ODP was recorded in 1982, April 5th. If you go higher up on the ODP, you see that it was signed by the only 2 property owners at that time. And I haven't heard anyone dispute the fact that everyone that was subject to the ODP at the time it was signed in 1982 agreed to be bound by it, agreed that it would be privately enforceable, and agreed that it would run with the land. So you might not like my definition of redevelopment, maybe Merriam-Webster doesn't like it. What I'm trying to do with that definition of redevelopment is fit this square peg into the round hole that the city council pushed on all of us. I don't envy Director Parker. I think he thinks he's doing the best he can with the mess that he's got. But if there are conflicting provisions under the base zone and the ODP, then the code tells you what to do. The more restrictive provision wins. I didn't address the procedural issue in my opening argument. We vehemently pushed back on that in my reply letter, which is item 22. Hopefully you've had an opportunity to review that, but the sort of high points there are that this appeal is what Kara Mueller told my clients to do in writing. This appeal is what Director Parker told my clients to do in writing. The developer objected to that and said this wasn't proper, and Director Parker came back with his sort of subsequent alternate reasoning, and he didn't address the procedural issue. I sent an email to Mr. Cox in June asking, the BOA rules, as you all probably can appreciate, aren't the most specific on some of the issues we're dealing with. Is this the proper forum? I didn't hear back on that email. And to date, I haven't heard anything from Mr. Tuthill respectfully saying that this isn't before you, that you don't have jurisdiction. And if you do, I would hope that your counsel would help you guys figure that out. In the 2012 rezoning hearing, something I hadn't focused on originally because, frankly, I didn't know that it would be in dispute. Item 23 in your packet, Director Parker specifically addresses the fact that he doesn't want all the power to interpret the zoning code. It's page 45. It says, we, meaning planning staff, had some concern about that interpretation being in one person's hands and unfettered power to interpret the zoning code. And as the person with that power, I don't need it. So one thing that we've done is added the ability to appeal any interpretation of the planning director so that any of my interpretations could be appealed, or future planning director's interpretations could be appealed to the Board of Adjustment. I would implore you to get to the substance of this dispute. It's briefed, it's ready to go. I don't think it would serve anyone to have a procedural hiccup that results in an appeal and then having things sent back down. With respect to Director Parker's 2 arguments, and they seem to be shifting a little bit, but the first one is the idea that because multifamily residential is now an allowed use, that somehow that nullifies any theoretically conflicting standards under the ODP. Crescent hasn't made that argument. I think they see the writing on the wall. The point here is that uses are not the same thing as standards. Ms. Stanek said it at the very beginning of this hearing 3 hours ago. The city council retained those ODPs that were not outdated, that remained in force as of 2012 as overlay districts to govern the allowable uses. These standards are still in place. Nothing has changed that. On the other standards provision, I think Board Member Stone has got it right on the nose. The only way to interpret this in accordance with Director Parker's decision is to say it's fair game, the ODP means nothing. But that doesn't make any sense because in 2012, when he was actually convincing the city council to adopt this stuff, he specifically said it's a misconception that PDs are going away. We're not going to change a single word in a single PD that's retained, like this one. On the specific standards that we brought before you tonight, starting first with density. Again, I think it's really important to see that the land use standards set forth in the ODP is based upon the total acreage of the entire Wilson property. It's 80 acres. And it sets a density standard on dwelling units per acre. That 4.75 dwelling units per acre is incorporating the entire 80 acres, which includes the wet fence farm parcel. So this provision is directly on point with what Crescent is trying to do here. They're trying to blow this cap. It's going to end up being, I don't know, 5, 6, 7 dwelling units per acre. The argument that the building envelope somehow provides an alternative standard under the base zone doesn't make any sense to me because that's a form requirement. And you can fit as many dwelling units in there as you can shrink down the different dwelling units. So that's not a standard. That's a standard for the building form. That's not a standard for density. On height, again, we've been over it. It's an apples and oranges issue. If somebody wanted to modify this ODP to incentivize low-income housing or LEED goal or any other admirable policy goal, that could have been done. It wasn't done in 2012 at the exact same time that the city council adopted this bonus for people proceeding under just a base zone. It reaffirmed the strict 42-foot height requirement at this property. And the reason it did that is because that property, that restriction is specific and unique to the context of this property. And again, I don't think you all respectfully should be in a position of avoiding what the city council did in 2012 by reaffirming the applicability of the ODP. And then lastly, on the architectural review, Ms. White sort of made this new argument that, well, the base zone architectural review is much more robust, and so I guess frankly, I don't really understand the argument. I guess it's the more restrictive provision wins. I guess they're conceding that piece of it. But ultimately, it's not one-to-one here because what the ODP is requiring is local architectural review. And the city's taken the position that we waived it. I guarantee you, if someone presents us with architectural plans, we will review them. And I'm here on behalf of my clients to tell you that tonight. I don't think that they can be held to some waiver argument maybe years before any of them were on the scene. The ODP says what it says. The city council reaffirmed it in 2012. And local neighborhood architectural review is what's required. So in conclusion, I would just end with my 2 points. If you find that these competing provisions, whatever the city council was trying to do in 2012, doesn't make any sense, then they gave you an out. They told you under 17.162A, the most restrictive provision wins. And here on each of those issues, that's the ODP. Secondly, a PUD can include a private covenant. I suppose I'll have to agree to disagree, but the 1973 Model PUD Act in Colorado, which was pushed by the city of Lakewood. Stanek mentioned the fact that Lakewood was sort of on the cutting edge of PUDs. It didn't actually have real zoning, quote unquote, I don't mean that pejoratively, but comprehensive zoning until 2012. Lakewood consulted on the 1973 Model PUD Act state that said a PUD can include private covenants that run with the land. That's exactly what this ODP is. It's never been modified with the consent of the homeowners that remain subject to that ODP. And again, I just submit to you, it's completely unfair to say that, well, whoever decides to redevelop it can ignore those standards. That's the opposite of what Director Parker said in 2012 when he said not a single word of ODPs like this one would be changing. Thank you all for your time.
Thank you. Thanks for observing your time. Okay, so that's the end of testimony, questions, and rebuttals. We're going to switch into board member discussion. It is, as I mentioned earlier, will be our painfully public process to come to some awareness of what sorts of things we want to have ultimately put into a resolution. We are not going to have that resolution tonight. Just, it will be compiled and we'll take action on it a week from today. So we're going to have discussion here and give some direction to Mr. Tuttle to craft a resolution for us. And I should point out that a resolution does not mean that we have come to consensus. There can be items in a resolution that any one or many or even all board members don't agree with, and we take action on it then accordingly next week, either voting for or against with amendments or whatever else. Is that a fair description?
I think it is, Mr. Chairman. You're required to take action on an appeal of an interpretation by resolution, and not presupposing what the outcome was likely to be tonight. I certainly haven't prepared one, but based upon the discussion you have, and give me some direction, I'll have one ready for next week.
I wouldn't say we prepared one, but I'll say we'll give you some aspects. Thank you. So we'll open it up to board member discussion, and I believe Mr. Cohn was first.
I'm embarrassed because I want to ask a question. I'm somewhat embarrassed because this is a question I should have asked far earlier, but it's a fairly simple and straightforward one. Is Carmel Oaks party in this appeal? And the second question is a little like unto the first. Does it extend at all into parcel G on the basic plan? I'm sorry to bring this up so late.
Yes.
I apologize, I had to consult with my client because the name wasn't ringing the bell. I've heard the name before, but it just had to jump to mind. Carmel Oaks is subject to the ODP in the far southwest corner, as you look at the map there.
Mm-hmm.
Carmel Oaks is not a party to this appeal.
Okay. I'll just note in passing that parcel G does not recite in the table that's been used by both sides, does not recite any maximum dwelling units, so.
I agree, and I think that is
okay. Just as a point of fact, I'd like to get that nailed down. For now, yes, I'll give my conclusions in turn.
Thank you. So, board member Bartlett.
Thanks.
It is listed there. It is.
Maybe we should stay on this topic for a second. It seems like.
Yeah, I apologize. I looked at it quickly. I believe if you track across.
Oh, I didn't track correctly.
Yeah,
Okay.
I didn't.
You're right, it's 69 maximum dwelling units. Okay, thank you.
How many are in that development?
I don't know, perhaps planning this.
Go ahead, Mr. Bartlett.
I'm just kind of wanted to open it for discussion since we didn't bring it up previously on the topic about whether or not this appeal is right. It's my opinion, and I agree with Mr. Silvestro, that the appellant was given an interpretation of the ordinance by the planning department. And then expressly told that there was a process for this appeal, which is why we're here. Just wanted to throw that out there to see if there's any discussion around whether or not other board members feel that this is right. I, for one, think it is.
I would agree completely. I think it's clear from the correspondence that the planning staff reached interpretation regarding what governs the site plan or the ODP, and they communicated that to the design firm. Following that, the planning director published his position, which was a reversal of that in essence. And so I think that action constitutes the opening. The conflict was created, and it is our job as Board of Adjustments to now make a decision when we have a conflict present. So I agree with you.
I agree as well.
I think that we are, that it is within our jurisdiction as well. I think that's my personal opinion.
That'll be the easiest part of the resolution to draft.
Check one. Mr. Barlow, was there more that you?
No, not for now. Okay, thanks.
Then I think Board Member Heald was next. Thank you, Chairman Miller. You know, in looking through all of the packet of information and focusing on item number 6, staff indicated to the developer, the design company, I believe specifically, that the ODP ruled over the underlying zoning. And following this, in his letter dated May 21st, item 10 in the packet, the planning director said the Wilson property ODP is still applicable in part on the property. So I think that the phrase in part introduced a problem in the sense that we have two directors. Staff member says it's applicable, director says it's applicable in part. And so what you have here is a published interpretation that created a conflict. And so then we come in or I should say the residents around filed their appeal in accordance with the instructions from the director. So I think we're on track that this hearing is valid. And what comes to the presence of to the center of my attention is the conflict provision, because by these steps I just described, the conflict has been created. So our duty, as I see it, is to address how the conflicting provision language in the ordinance prescribes a solution to a conflict. And it clearly indicates that the most restrictive provision will be enforceable in the event of a conflict. And I think Mr. Silvestro has made that case clearly. The director confirms that the ODP is part of the zoning regulations. He's made that clear tonight. So as such, the ODP is clearly subject to this conflicting provision language. One interpretation, excuse me, I'm getting tired, might be that the ODP is not part of the zoning ordinance, therefore it's not subject to the conflicting provision. But I think we have confirmation that the ODP is indeed part of the zoning regulations. So I'm looking to the conflict resolution language, which clearly speaks to the fact that the most restrictive provisions should apply. Regarding the fact that the planning director has stated in some of the correspondence that zoning would apply when an ODP is silent as to particular standard, that's true. But in the case of this property, the standards of number of units and the standard of height is clearly addressed in the ODP. So I don't see any authority to alter those. In other words, I think the ODP is really clear on those issues. I mean, it's not silent. So there's no ability for an interpretation to come in to overrule those issues. See what else here. Regarding the lead bonus, one of the things that concerns me there is that the lead bonus the lead bonus applies to zoning. But I think what I'm trying to lay out here is the position that in my understanding of all the documentation here, in this case, the zoning is not the operative provision, it's the ODP. So you're trying to apply lead zoning, which is designated to be applied against zoning, or lead bonus, which is designated to be applied against zoning numbers, and zoning numbers are not what rules here, the ODP rules here. So I don't see it valid in any way, shape, or form that a lead bonus would apply to an ODP. So basically, I'll be voting to uphold the appeal.
Board Member Cohen. Well, first of all, with respect to jurisdiction, I think this has already been opined on by other members. Yes, we certainly should take jurisdiction. I think basically under the charter, which among other things I helped write. To hear and decide appeals from and review any order, requirement, decision, or determination made by any administrative official charged with the enforcement of any zoning ordinance adopted pursuant to this section. I think that's easily broad enough for us to not really read any further. So we're doing exactly what we should be doing in that so far. I think Director Parker's in the two letters that are in our record are appropriate to the current zoning. I would leave untouched the provisions of the ODP that place any agreement among the landowners. I think that's not within our purview. I think we are here to enforce zoning ordinance, not what purports to be a private agreement. And I could go into some detail on this because there's a contention between the parties in terms of what the ODP really says. And I would not disturb any of that controversy. We're here to uphold or to not uphold an ordinance. And that's as much as I'll opine on at the present time. Thank you.
Thank you. Other comments? Yes, please.
So there's a lot of complexity to this issue, and we've heard a lot of issues. A lot of opinions have been brought forward. I agree, it is our job to enforce the code. And we've talked a lot about different sections of the code. Talked about 17365, which says redevelopment could use either the standards of the ODP or the base zone. But if you look at this part of the zoning code 17162 entitled conflicting provisions that Mr. Silvestro has shared with us, where any regulation requirement, this is a requirement, the ODP, or condition, I'm not going to read it for you then, but the more restrictive applies. I think that's pretty clear, and it's under general provisions in the code. That means general, it applies to 17365. I think this is pretty black and white. I think the code is pretty black and white. Since we have not done anything about ODPs to to amend them to be under the LEED certification or anything like that, it looks like a contract to me. It looks like it needs to stay in place just because it's old, it's been signed. There are two private parties on those signature lines. There are city officials on those signature lines, and just because it no longer serves some stakeholders, I don't believe that that should be a basis for voiding it. And I think if you join this ODP, try to join it and merge it with in the way that has been described to us tonight, I think it essentially makes it null and void because the provisions that are in there are not being followed. So I will be voting to support the
Well, I will comment on that we've come down to these two sections of the code, 17.1.6.2, entitled conflicting provision. I don't see that takes precedence over 17.3.6.5. I suppose that my thoughts about it are 17.3.6.5 actually address what most everyone is concerned about anyway, and that's property owner rights. And this is saying that a redevelopment within a PD district may apply either the standards of the base zone district or the standards of the ODP. That seems to be going to the basic property rights that I think we all try to uphold anyway. I'm also not sure that Section A of 17.1.6.2, where it says where any provision of this zoning ordinance conflicts with any other regulation, requirement, or law, I guess we would have to be saying that this ODP is a regulation, a requirement, or a law. When I read that, it sounds more like we're talking about ordinances passed by the city council. I don't see that one as taking precedence over 17.3.6.5. And we don't have to argue that out tonight either. We simply at some point will vote about it. And one of the goals for us is to give Mr. Tuthill some guidance with regard to the 4 topics that seem to be what we are addressing. The first was whether we have the authority to review this. I appreciate Board Member Cohn's perspective and wonderful memory to recall that you wrote that so long ago. And what was, I think it clearly shows we do have the authority. The next was about height. I think that I think all height and density both will be determined by whether we are ultimately whether it's the one or the other of those 2 standards that apply, or those 2 aspects of the code. I don't know if that's good enough guidance on, with regard to height and density for crafting a resolution. And I also don't know whether we would need to come to some agreement on, or even agreement, but whether perhaps whether it comes to vote about which of these, since they seem to be in conflict, which of these parts of the code we should be following. No, this is for Mr. Tuthill. Should that be a part of our resolution or something that precedes it?
Mr. Chairman, I have some opinions on this topic. I'm not prone to give legal advice other than in executive session. In general, I do favor providing some prefatory language in a resolution along the lines of, we hereby find, we hereby apply the following. We refer to particular code sections. For example, the jurisdictional aspects might make some reference to the fact that the appellant was informed that this appeal process existed and that the code and the charter provide that, at least the code does. The Board of Adjustment has the authority to hear appeals of planning director interpretations. So I would include some language like that. So ultimately, based upon where the kind of the chips fall, I would be inclined to put some language in a resolution that builds up to a now therefore component. But at the moment, I'm not hearing enough consensus to know to put in that resolution except jurisdiction.
My comment about the third, or actually fourth, I guess, architectural standard, what we have heard is that there was no committee and still is no committee, and so I'm not sure that, I think that the code does address that, and it's not a case of conflicting standards, it's a case of what doesn't exist. We can put something into a document, but if it's never followed through, I'm not sure where that leaves us, but it seems to me it leaves us with the alternative of not following that standard, in this case, an architectural standard. I believe there's some other comments people would like to make, so that's good. Board member Heald.
Thank you. With regard to your question about height and density in which it lies, the argument I tried to lay out and was probably not effective with is that the ordinance clearly states that in the event of a conflict, the most restrictive provision applies. And as I stated clearly, we have a conflict. So I think it's crystal clear that with regard to height and density, the zoning ordinance apply.
Yes. Board member Cohen.
I also did not opine on architectural standards, and I do accept Mr. Parker's note and the note in our file that I think Mrs. Moore's findings also is that the vanishing architectural committees is not only in this instance, but in a number of other instances, and I could recite even others within my casual knowledge where these committees have either never met or they met at the time of the original build out and then were never continued. So I think I would follow the more sensible rule here that where they simply haven't existed, we not try to bring them back into existence now. And it is in fact, a waiver. Height and standard, I think I'll leave within the rest of the ODP in terms of something that I would like to see leave untouched and go with the current ordinance, at least in construing it. That we're not the most competent body to decide what the ODP, what kind of burdens the ODP puts on the public parties, and to the degree that it may have given some rights to the successor landowners. And I would stay away from that controversy. Those are private controversies.
Board member Bartlett.
Yeah, I guess I just wanted to add or speak my opinion with regard to the ordinance section on conflicting provisions. There's been some discussion from Board Member Stone and Board Member Heald about how that applies to density and height, but it doesn't seem fair to me to leave out the architectural committee component of that, and I think I'm reading into what Chairman Miller was thinking or saying, in that the 2012 ordinance and the process that was laid out in discussion tonight from the ordinance requirements on architectural review is much more stringent. It's a higher standard than what the ODP mentions. And so I feel like that trying to apply the section in the ordinance on conflicting provisions is kind of moot in that point, because the 2012 process, at least for architectural committee review, is much more stringent. So I don't think it's fair to pick and choose which part of this appeal can draw from that section. I tend to read 17365A clearly in that, it doesn't give the city the authority to apply review under the ODP after the developers requested to use the base zone of M&S in this case. And to me, it's very clear, and I agree with Chairman Miller that section 17365A to me speaks to density, height, and architectural review more appropriately than the conflicting provision does.
Thank you. Board Member Stone.
Actually, my light's been. That light's been on, but I would like to answer your thing. So since there really wasn't an architectural review at all, I don't know if we can say that they would have been more restrictive or not. So I'm not sure if that conflicting provisions paragraph would apply. We just don't know, we're speculating.
I respond to that too. I think this application hasn't had a chance to get there because we're here in this discussion. And if you look at the process that's laid forth in the ordinance for architectural review, as mentioned previously, it's a lengthy process. We're reliant on professionals who've been hired within the city to perform that review. And to me, I would be more comfortable with relying on or deferring to their professional judgment than a committee that doesn't exist. Sure. Yeah.
But and that's nice, but it's still speculative. There is no conflict because there has not been an architectural review. There has been no determination, there's been no judgment, recommendation, there's nothing to conflict with the code, nothing. So I don't think we can apply the conflicting provision paragraph to the architectural review because it has no code.
I think we're in agreement with that, maybe just disagreeing on the way we're interpreting that. I agree that we should not apply the conflicting provision to the architectural review. I guess I was just trying to say that I'm more comfortable, I guess, if, I don't know, now I'm getting lost in my train of thought, but that's what this is for, I suppose. It is, thank you. Yeah.
Thank you.
I would just add that I think the conflict is in that what's being done as a common practice and what's not being done as a common practice. It's not being done, and yet there's the discussion that, oh, but it could be done. So the conflict is still in how it plays out. Not specifically in this case, well, yes, specifically in this case, but also broadly, there aren't as many reviews of this case anymore, in my opinion.
I might add to this discussion too that it isn't the case that there's no other developer. There's lots of other buildings, and there was no architectural review committee convened for any of those. According to some of these really strict interpretations, I would suggest that if a developer wanted to just follow the ODP standards, but they didn't bother to convene an architectural committee, they could do whatever they want. I think the point of this is that the city has standards and that would apply instead of that. So this is a case where they haven't convened one, there's been no history of it. I don't know why. If an objection at this point is that they actually want to convene a committee, I think I would tend to agree with, in that sense, with the director's interpretation that there has been none, and at this point, really relatively late in development of this property, it seems more a point of argument than it does real concern about what's built there. If there was real concern about what was built and what it looked like, they would have convened an architectural committee before. On that point, that's how I feel. Board Member Heald.
Yeah, continuing on the Architectural Review Committee, while it has been, clearly established that there's not been one established or, convened on prior development under this ODP, I don't see that precluding the formation of one now. I don't see that by lack of exercising a right under an ODP, that right itself evaporates. I don't see that. I think action would need to be taken to remove an ingredient of the review committee in order to actually say that it's no longer valid. And also with regard to Mr. Silvestro's comment that a committee would indeed be reviewed consisting of him and others once they have a plan to review. So I think the underlying language that creates the committee is still valid. And I think we have a representation that it would be up and running in this case. So I think we need to consider that.
Is there other discussion? So I'd like to make a motion that we go into executive session.
Second.
Do we need a?
Can we go to purpose?
Oh, you will.
Yes.
Mr. Chairman, Colorado Revised Statutes 24-6-402, 4B allows the members of the local public body, upon announcement by the local public body to the public of the topic for discussion in executive session, they go into executive session if they cite the specific aspects of the law that allow them to do so. Section 24-6-402, 4B provides that conferences with an attorney for the local public body for the purposes of receiving legal advice on specific legal questions is an appropriate topic for executive session. Mere presence or participation of attorney in an executive session of the local public body is not sufficient to satisfy the requirements of the subsection 4. Should you choose to go into executive session for the purposes of receiving legal advice, I am happy to provide it as a special counsel to the Lakewood Board of Adjustment. And you would refer to section 24-6-402, 4B of the Colorado Revised Statutes.
Yes, well, I would amend my motion to include that was the intention, to get legal advice with regard to the resolution.
And I'll second again.
Okay.
Preparing a
In an
motion
express
is not
purpose.
legal advice.
Pardon me?
And preparing a motion is not legal advice.
We aren't writing a motion in the executive
Oh,
session.
that's what you had said.
The outcome of this is to ultimately to have a resolution. We're not writing the resolution. We're getting legal advice.
On
I'm sorry?
what? I mean, it doesn't seem that there's a real reason for an executive session. Executive session for
I believe that
negotiations and-
Mr. Chairman, I believe Mrs. Kettner needs to review lecture number 2 on civility.
Oh. I've already moved myself, thank you, Mr. Coleman.
So,
And please, and I hopefully you all review executive session and what is really allowed by the law under executive session.
Mr. Tuttle, do we need a voice vote or a?
You need a majority of the, there's been a motion, there's been a second. you need a majority vote of the members present to go into executive session.
Okay, we'll just, we need to not do a voice vote, and please vote. If they're not turned on. Now they are. It says not everyone has voted, but actually everyone has voted. Oh, Commissioner Cron, you have not voted. Oh, excuse me. I'm sorry. Okay. There we go. So we will go into executive session. Excuse us, everyone. We will make it as brief as possible. Thank you.
So I got to get the more space. Now I'm going to.
I told you I put my suit on 20 times. Okay, talk to you later. Thanks for coming.
No.